All right. All right, good afternoon, ladies and gentlemen. I'd like to call this meeting back into session. It is 1:17. And Ms. Cicchetti, let's pick up right where we left off, having riveting conversations about, from taxpayers. And Ms. Thompson, it's good to see you, hydrated and back and ready to go. All right, let's hit it.
Okay. The next public comment that we have is from Denise Conway, ACT Holding, Inc. The comment. Several years ago, we applied for property tax welfare exemption for our newly formed 501c2. We had this exemption under our 501c3 and created a 501c2 as a real estate property holding company. Several years later, and multiple phone calls and letters to and from BOE with attorney intervention, we still were not getting anywhere. We reached out to our local assemblyman's office and were put in touch with two of his employees. They referred us to Lisa Thompson, the taxpayer rights advocate. Within 5 minutes, she told us we were never going to get the tax exemption under a 501c2 as there was no legislative provision for that. My comment is this: could it be recommended to BOE that they specifically point this out during the initial finding or subsequent phone calls rather than continuing to request more documentation after a long period of time with no communication? We wasted several years in trying to establish something that we were never going to be eligible for. Lisa's experience, availability, and general kindness to our plight got us re-energized into obtaining the exemption. More lawyer fees later, we just received our IRS designation and are now in the process of applying again for the BOE for the property tax exemption.
We appreciate Ms. Conway submitting comments and her kind words. My team deserves the credit. Without the hard work and the dedication of them, we would not be able to help so many taxpayers, so I thank them. In this case, we help the organization understand the requirements for the welfare exemption and an organizational clearance certificate. We are glad that they are on the right path right now, and we're happy to coordinate with the assessor's office to expedite excuse me, the granting of the exemption on the property once the organizational clearance certificate is issued. We are always happy to help nonprofit organizations because they serve a vital role in the community. Unless the members have any questions, we can read the next comment.
Thank you. Please, next comment.
Yes, the next comment and the next public comment is from Shari P. from Santa Monica to the California State BOE. I know you've a difficult job sorting through the rules under Proposition 19's property tax reassessment after a death. But for the hundreds and soon thousands and millions of people who are unaware of the impact that this ill-thought law, it is not just difficult, it is catastrophic for their immediate families and generations after. The California Association of Realtors' real reason for adding this to the ballot was to increase the number of properties for sale and ultimately line their pockets with more money at the expense of those who will not be able to pass on their family homes and businesses to their children without harming them financially. This was a flawed law that we hope will be repealed. Not one person I spoke to who voted yes on this proposition understood that they were voting for because this aspect of the proposition was hidden behind the two more important and prominent aspects. For age 55 and over, the transfer of their existing property tax assessed value to a replacement home and allocating state revenue and savings to wildfire response. If there is an opportunity to repeal this part of the proposition in the future, I hope you will support it in any way possible.
We appreciate Sherry P.'s comments. Our agency cannot address the reasons why an organization supported the ballot measure or not. She would have to contact that organization. We don't have any oversight over the Realtors Association. After the passage of Proposition 19, the Howard Jarvis Taxpayers Association proposed an initiative measure to reinstate the old rules of the intergenerational transfers, but they were unable to obtain the required number of voter signatures to get it on the ballot by November 2022. The taxpayer hopes that it gets repealed in the future. Our agency doesn't have the authority to repeal that constitutional amendment, and the taxpayer may wish to contact her assembly or senator. Unless there are any questions by the members, the next 5 written comments all express support for repealing Proposition 19. So I won't be providing remarks on each of them. I'll provide them in a group after read by board proceedings.
All righty.
Thank you.
Here we go, the next 5 public comments. The first one is by Matthew Chan from Hayward. Prop 19 will hurt our family, and I support repealing it. The next one had no name given and no location given. Prop 19 will hurt our family, and I support repealing it. The next one was from Gemma Cornfield from Santa Monica. Prop 19 will hurt our family, and I support repealing it. The next one is from Lori Snyder from Santa Monica. Prop 19 will hurt our family, and I support repealing it. Thank you. And the next one is from a person just left their initials, S.P. from Santa Monica. I do not agree with how Prop 19 was passed regarding the reassessment of property taxes of inherited properties. I will vote to repeal Prop 19.
So the written comments for submissions 10 through 14 that the board proceedings clerk just read, all commented on support regarding repealing Proposition 19. Again, to repeal it, it would require a constitutional amendment, and then they should contact their legislator.
Thank you.
All righty. The next public comment is from Farah Presto Cha. Earlier this year, I gathered door to door hundreds of signatures to repeal Prop 19, the death tax. My understanding is that if we get enough signatures, then the appeal would get on the November ballot. I am not certain of the result of the effort, but I am hoping that you will support this effort. Thanks, Farah.
We appreciate those comments. She asked for the results of signatures. Again, we are aware of the Howard Jarvis Taxpayers Association, their proposed initiative measure to get signatures to place the intergenerational transfers, Proposition 19, basically to repeal that. However, they were unable to obtain those signatures.
Thank you.
The next public comment, no name was given and no location was given. You have a difficult job sorting through the rules under Prop 19's property tax reassessment after a death. But for the hundreds and soon thousands and millions of people who are unaware of the impact of this ill-thought law, it is not just difficult, it is catastrophic for their immediate families and future generations. The California Association of Realtors' real reason for adding this to the ballot was to increase the number of properties for the sale and ultimately line their pockets at the expense of those who will not be able to pass on their family homes and businesses to their children without harming them financially. This was a flawed law that we hope will be repealed. No, not one person I spoke to who voted yes on this proposition understood what they were voting for, because this aspect of the proposition was hidden behind the 2 other important and prominent aspects. For age 55 and over, the transfer of their existing property tax assessed value to a replacement home, and allocating state revenue and savings to wild response. If there is an opportunity to repeal this part of the proposition in the future, I hope you will support it in any way possible.
We thank the anonymous person for submitting these comments. The comments submitted were pretty similar to that was submitted by Sherry P. on August 28th at 11:32 a.m., and I've already responded to that. But basically, the repeal of Proposition 19 would require a constitutional amendment, so she should contact her legislator, assembly member, or senator's office to look into that. So for the next written comments, they all express support for repealing Proposition 19. So for comments 17 and 18, the board proceedings section is going to read that first.
The first one, no name was given and no location was given. The comment, Prop 19 will hurt our family, and I support repealing it. The next public comment was submitted by Gordon Chin from Oakland, California. Prop 19 will hurt families, and I support repealing it.
We appreciate Mr. Chen and the unnamed person submitting comments in support of repealing Prop 19. The constitutional amendment would be required to repeal all or some of the Proposition 19 provisions. So again, they should contact their legislature. So for the next comments, unless there are any questions or comments by the boards, comments number 19 and 20 also are identical, so board proceedings will read those together as well.
The first one is no name was given, but a location of Santa Monica, California. Myself, my wife, 2 adult children, and adult son-in-law agree with the statement below. You've had a difficult job sorting through the rules under Proposition 19's property tax reassessment after a death. But for the hundreds and soon thousands and millions of people who are unaware of the impact of this ill-thought law, it is not just difficult, it is catastrophic for their immediate families and future generations. The California Association of Realtors' real reason for adding this to the ballot was to increase the number of properties for sale and ultimately line their pockets at the expense of those who will not be able to pass on their family homes and businesses to their children without harming their family financially. This was a flawed law that we hope will be repealed. Not one person I spoke to who voted yes on the proposition understood what they were voting for, because this aspect of the proposition was hidden behind the 2 other important prominent aspects. For age 55 and over, the transfer of their existing property tax assessed value to a replacement home and allocating state revenue and savings to wildfire response. If there is an opportunity to repeal this part of the proposition in the future, I hope you will support it in any way possible. The next public comment is no name was given and no location was given. You've had a difficult job sorting through the rules under Proposition 19's property tax reassessment after a death. But for the hundreds and soon thousands and millions of people who are unaware of the impact of this ill-thought law, it is not just difficult, it is catastrophic for their immediate families and future generations. The California Association of the Realtors' real reason for adding this to the ballot was to increase the number of properties for sale and ultimately line their pockets at the expense of those who will not be able to pass on their family homes and businesses to their children without harming them financially. This was a flawed law that we hope will be repealed. Not one person I spoke to who voted yes on this proposition understood what they were voting for, because this aspect of the proposition was hidden behind the 2 other important prominent aspects. For age 55 and over, the transfer of their existing property tax assessed value to a replacement home and allocating state revenue and savings to wildfire response. If there is an opportunity to repeal this part of the proposition in the future, I hope you will support it in any way possible.
So the comments submitted by the 2 unidentified people are the same as what was submitted previously by Sherry P. earlier on. So this is the 4th comment that has very similar verbiage. And basically, in order to repeal Proposition 19, it would require a constitutional amendment. So she may wish to contact the senator, or they may wish to contact the senator's office or assembly people. And finally, if they have questions about the Realtors Association, why they supported it, then they should contact that organization.
Okay, thank you.
Alrighty, the next public comment is no name was given and no location was given. Prop 19 passed in the 2020 election will place undue burdens on our family. Urge its repeal.
Okay.
I'm going to just go to the next one. Are we okay with that?
Yeah, no, just was checking that. So, so yes, so for that, again, the same issue is that our agency does not have the authority to repeal a constitutional amendment.
Okay.
All righty, the next public comment was submitted by a Jane W. Kohler, retired LAUSD teacher. I am in favor of returning to Prop 13, in which the family retains the tax base of the family home upon inheritance. As a teacher, I bought our family home 40 years ago in the hopes that it would be the basis of family wealth. Under Prop 19, it will have to be sold in 1 year, so my son cannot move into it because his job is elsewhere. Retaining my tax base would allow him to retain the home until he retires.
So we appreciate the comments that were submitted. This person is concerned about her son receiving the exclusion when the property is transferred to the son by inheritance. One of the requirements of Proposition 19 is that the property continues as a family home. So unless that property would be the family home of the parent and continues to the child, then it would not qualify under the existing property tax law.
All right, thank you.
The next public comment was submitted by Charles B. Silva, co-founder, Silva Brewing, Paso Robles, California. Business property tax is a completely unfair tax. No consideration is given to capital-intensive business, especially small businesses. There should be an adjustment based on profit or gross receipts versus actual property. I'm in a building where the neighboring business pays 1/10 the amount of tax that our business pays, and they likely make more revenue than we do. How is that fair? Assessments don't realistically depreciate value in personal property and fixtures over time. It's also completely unfair to tax tenant improvements like concrete, plumbing, and electrical work that simply cannot be resold and rather adds value to the landlord, if any.
So we appreciate Mr. Silva submitting comments. The law provides for taxation of business personal property in California, and it is valued at market value each year with that. So again, a statutory change would be required to change that.
The next public comment was submitted by David Frankville from San Diego, California. I am gravely concerned about the erosion of the protections given to homeowners by Proposition 13. I am old enough to remember the distress my parents had about losing their home to the combination of inflation and high taxes. My father was a school teacher with a modest income. It's sad to think that a person who has worked their whole life to own the security of owning their own home, then retire, and then live in fear that they could lose their home because they cannot pay the property taxes with their fixed retirement income. Please don't let this ever happen again.
We appreciate Mr. Frankville's comments about Proposition 13. Proposition 13 was passed by the voters in 1978 and continues today. It limits the property tax rate to 1% plus local approved voter bonded indebtedness, and it limits assessment increases for assessed value, specifically to the factored base year value, to 2% a year. California's property tax system is an acquisition-based system. When property undergoes a change in ownership or new construction, it is reassessed to market value. His property should continue based on when he purchased the home, with the inflation factors to come up with the factored base year value as published by our agency. If he finds that he is unable to afford the property taxes, then he may wish to look into the property tax postponement program offered through the State Controller's Office. Unless there are any questions or comments, then we can go to the next written comment.
Did you want to?
Oh, yeah, I was just going to see if they had any questions.
Go ahead.
No comments?
You
Okay.
just wanted to, Ms. Thompson, what'd you say?
I just was wondering if there was any comments. I didn't know because it was the Controller's Office. So the next three written comments all express concerns about Proposition 19 and its consequences. So rather than reading them each, then board proceedings will be reading those, number 25, 26, and 27 in order.
Alrighty, the next public comment was submitted by Catherine R. Dreyfus from Santa Monica, California. Proposition 13 deserves to be updated in a much more thoughtful manner. Proposition 19 will be harmful to my family. Please repeal it. Thank you, Catherine Dreyfus. The next public comment was submitted by Ann Greenspun, RN retired, Santa Monica, California. She is a Santa Monica taxpayer and board member of the Santa Monica North of Montana Association. I am representing myself only. I am voicing my thoughts to you regarding Prop 19. Please read on. It was an eye-popping misnomer that hid the enormous consequences of this tax on individual homeowners. I am a retired ERRN who worked closely with the Red Cross during fires. So of course I want to help out those most affected by some of those issues that headline Prop 19. The home tax was couched, hidden, and not mentioned in this promotion. Throughout the past 45 years, my husband and I thought and took comfort in the fact that when we passed away, our Santa Monica home will assist our 3 children and our 5 grandchildren with the future finances. It gave us great comfort. However, with the giant-sized bite that will now be taken from our safety net home, none of our children will benefit like we thought they would. Not one could afford to live near us. Not only that, only the rich will be able to afford paying these giant home tax increases. This greatly squeezes out the middle-income buyers, which all my children are and work hard to keep afloat. Please reconsider solutions so the property taxes are not onerous on my family. Perhaps combining a group of concerned citizens to look at solutions to this matter will give us some hope and relief. If this aspect of Prop 19 can be repealed within a thoughtful amount of time, it will let me know you are indeed listening. Our communities are being taxed to death, while the state is involved with these proposals without supporting them financially. The California exodus will continue. Please help. Respectfully, Ann Greenspun. The next public comment was submitted by Michael K. Stevens from San Jose, California. I think Proposition 19 was recently passed was a fraud on the voters of California. It was clearly an attack on Proposition 13 and 58 by eliminating the inheritance of property tax basis between parents and children and/or grandparents and grandchildren, but masqueraded as a benefit to people whose houses had burned down in the California fires, already probably covered by exemptions from reassessment, and a boon to older people who wanted to move and keep their bases after their move. Again, already mostly covered for the 8 or 9 counties to which they could already retain bases and which were arguably the counties to which they would likely move. Adding superfluous issues to that which was directly involved, the elimination of basis inheritance, should be illegal as confusing and unnecessary. Voters just can't handle focusing on 2 issues at one time. Good job.
We appreciate the comments submitted by Ms. Dreyfus, Ms. Greenspun, and Mr. Stevens. However, Proposition 19 was a constitutional amendment passed by the California voters. Our agency is not empowered to change that law, and like California assessors, our agency is responsible for implementing law. Constitutional amendment would be needed to change.
Mr. Gaines.
Thank you. I want to clarify that these constituents can call their local legislator and ask for a fix in the legislature, or there's a path of looking at bringing forward an initiative. So, and just as you clarified, we don't have the power. We've been, our duty is to implement. And I know we've said this many times, but I just want to clarify that as more of these comments come forward, that it's going to take action of Californians to step up and take the necessary steps to change this. And I'll do whatever I can to help them out. And you could talk to my colleagues, and I'm sure they do the same. So thank you.
Exactly. Thank you. And they could contact the Howard Jarvis Taxpayers Association and look into that as well.
Thank you.
Oh,
Please say that a little bit louder
Oh,
so we can
I
hear
was
you.
just saying that, in addition to contacting their assembly member and senator's office, they could also look into contacting the Howard Jarvis Taxpayers Association to see if there is any other future, measure planned.
Right.
Okay.
The next public comment was submitted anonymously and no location. Retirees and middle and low-income residents are being taxed to death, where many are not able to keep their homes or buy a home. Added with inflation issues, doubling or tripling garbage pick fees and bins for green waste, household waste, and recyclables is a great burden on residents. In addition, my homeowner's insurance, which last year was $1,125, now is $5,200 a year for California Fair Plan, as I live in a foothill community caused by the irresponsible lack of proper forest management, which directly leads to the mega fires California experiences. We are losing our state as a functional entity. We are being taxed unmercifully for pet projects and ideology not based on reality. Please stop this ongoing insanity, as California has already lost a representative in Congress due to people fleeing the state while politicians vote more raises for themselves. This madness will have one result: anarchy and social upheaval. Start by containing costs, not increasing the cost to residents. Residents will reach a breaking point and will look for those causing the attacks on the middle and low classes. Reduced property taxes would be a start due to the current economic environment and the crashing of the overall housing market.
We appreciate this person submitting comments. The person expresses comments about fees that our agency does not administer, as well as homeowners insurance. With respect to the property taxes, they indicate reducing property taxes would be a good start to the current environment and housing market. The ad valorem property tax rate is set forth in the law, and one of the provisions of Proposition 13. It is a 1% basic countywide tax rate plus voter-approved bonded indebtedness. To change that rate would require a constitutional amendment, so they would need to seek a legislative solution. Unless the members have any comments, we can read the next comments.
The next public comment was submitted by Rod Davenport from Wilton, California. I want to make note that Mr. Davenport submitted this public comment 2 times. I'm only going to read it once. Members of the board, I'm asking you as a lifelong resident of California not to increase any taxes. I'm a retired resident on a fixed income, and I cannot afford any more taxes. As residents of California, we already pay the highest taxes in the nation. I love California. I was born here, raised my children here. Please do not force me to leave this great state because of increased taxes. Thank you, Rod Davenport.
We appreciate Mr. Davenport's comments. He indicates he does not want increases in taxes. As far as the tax rate is set in the Constitution, so if there were any changes, a constitutional amendment would be required. The tax rate and its composition is discussed in our agency's publication 29, California Property Tax and Overview. And unless the members have any questions, we can go to the next commenter.
Let's go.
The next public comment was submitted by Paul Bartek, Burlingame, California. Proposition 19 actually has 3 different propositions in one. It was not put on the ballot as far as the property tax timely, and I believe it was Jerry Hill got a law passed to get it on the ballot. The first two measures were a decoy, which people believe were good, and they may have not even read the part about the property tax. It was a very sneaky, arbitrary, blatant disregard for what our country stands for. The whole Proposition 19 should be abolished, and each topic, wildfire, county tax transfer, and parent to child, should be replaced on separate propositions. Very truly yours, Paul Barton.
We appreciate Mr. Barton's comments. Abolishing Proposition 19 would require a constitutional amendment. Unless there are any comments, we can go to the next speaker or
Next
commenter.
speaker.
Commenter.
The next public comment was submitted by Marcus Crawley from Oakland, California. Several years ago, I talked with the Alameda County tax collector. I complained that Alameda County annual tax statement is skimpy on details. The annual secured property tax statement lumps all the countywide voter-approved debt services into a single line item, so the taxpayers cannot easily understand the source of the tax. The various city and school bonds should be identified with the voter-approved ballot measure. The existing system of minimal information helps create poorly informed taxpayers and voters. When taxpayers don't confront their tax assessment statement, they can far too easily vote in for new taxes without realizing the extent of ongoing taxes. Mr. Levy explained that his department cannot provide more information because the pieces of paper is not big enough. Each tax and bond should have at least a line item explaining the source of tax. For example, Measure AA, 2018, School Prop 39 Bond, Tax, $720.14. Also, the BOE should denounce the popular practice of describing ballot question for general tax as may be spent for the following services X, Y, and Z. The implication is that the general tax will be approved to be spent on your favorite service. In fact, the ballot question for a general tax should state, this tax will be spent on any regular government service at the complete discretion of the government. The state of California must banish the ongoing misleading general tax description. Thank you, Marcus Crawley.
We appreciate Mr. Crawley submitting comments. Our agency does not have oversight over tax collectors. However, the Taxpayer Rights Advocate Office does help taxpayers with problems they have with the assessment or collection of property taxes. While the tax bill itself may not break down the specific voter-approved debt service, that information would be available from the county auditor's office. County auditor's office is responsible for computing the taxes, and the tax collector is responsible for collecting them. Unless there are any comments, we can move on to the next comment.
Next comment.
The next comment, it was submitted by Jin Ling Fu. I do not have a location. Hi, I'm submitting Form 1373 to the hearing, which I'd love to attend in person, but can't afford to send in my written comment about property tax. Please include my statement at all hearing proceedings and feel free to contact me for any further comments. I want to petition the government to stop any and all property tax increases. I should not be forced to sell my home, nor to be out on the streets because of unbearable tax burdens. Firstly, I do not have children, so why should I be forced to foot the bill for community colleges and unified schools, totaling $998? Also, the voter indebtedness is very unfair to the homeowners. The MRCA greedily proposed various fees, and they used very deceitful language in their campaign throughout the neighborhood to impose extra fees that put burdens on poor homeowners like myself to bear, while other people in the area who vote for such measures like HH do not have to pay a penny. And my request to the MRCA liaison, went unanswered. It's time for the BOE to take action and alleviate our tax burdens for the majority of homeowners who are not rich and cannot sustain such brutal taxation tactics.
We appreciate the comments submitted by Jen Hugh expressing concerns on voter indebtedness and ask the BOE to alleviate tax burdens. Our agency does not have the authority to change the tax rate or voter indebtedness portion of the property tax rate. The California Constitution established by that sets forth the ad valorem property tax rate at 1% plus local voter-approved indebtedness. So certain debt is a matter of a particular county or city within that county. Unless the members have any comments, we can go to the next comment, which will be actually 3 comments read consecutively.
All righty. The next public comment was submitted by Mary Figras. The part of Prop 19 that changes the property tax rate is unfair to those of us who have planned on our homes of 48 years being a legacy home for our next generation. This enormous change of property tax at our deaths would prevent our children and grandchildren from keeping the home in the family. Parts of Prop 19 are good for everyone, but that section is an affront to those of us who have planned for years to help our family. Please revoke that section. If put to a public vote, I'm sure it would pass. The next public comment was submitted by Lori Winters from Santa Monica, California. I believe that Prop 19 will hurt my family, and I support repealing it. Thank you. And the next public comment was submitted by someone named Gina. No location. Save family homes, farms, and businesses. Reinstate 58 and 193. I cannot believe how many people I encounter who have no idea Proposition 19 passed and what the harmful effects of Proposition 19 are. We are only starting to see the long-term effects. More properties for sale, not selling, and long-term working middle class leaving California is no coincidence. I really hope we are able to get the harmful effects overturned by the November 2024 ballot for Californians before it's too late and we lose too many of our working middle class. Sadly, our representatives in 2011 took away our rights to citizens' initiatives and vetoes through SB 202, and the people have had to suffer with those losses of a family member through COVID times without consideration from our representatives, despite SB 668 by Bates and AB 9 by Kiley proposals. Having volunteered for the Repeal the Death Tax Initiative, many people who couldn't attend the call have shared their stories with me. These are artists, teachers, people who have given up careers to be caretakers for elderly parents, realtors, immigrants, minorities, senior citizens, disabled and low income. The people Proposition 19 was intended to help, and the people who have worked for the American dream, to have it stripped by an unconstitutional policy that does not protect ownership rights afforded by both our federal and state constitutions. Thank you for allowing us to platform to be heard. Repeal the death tax. Anyone interested in joining us to educate the people, visit forcalifornias.com.
So we appreciate the comments submitted by Ms. Fergus, Ms. Winters, and Gina, who didn't identify her last name. They each expressed concerns about Proposition 19 and hurting their family. The Proposition 19's intergenerational exclusions were different than prior law, which many taxpayers are concerned about. Any changes would require a constitutional amendment, so these taxpayers may wish to reach out to their assembly or senator's office or contact the Howard Jarvis Taxpayers Association, who submitted an initiative previously.
The next public comment was submitted by Philip Reed. No location. Property tax on the personal residence of the elderly should end at age 65, as most retirees have little savings and no pension other than a tiny Social Security stipend. and huge medical expenses, which leaves little for paying property taxes on a home in California. It should be unconscionable to force the elderly out of their homes they worked entire lives to pay for, only to discover the tax payments never end, long after their jobs have ended. In effect, the legislature has destroyed the concept of freeholder of land. When taxes act as rent that must be paid to keep one's home, making government the landlord. Taxing the elderly out of their homes is clearly wrong, but nobody in Sacramento seems to care. It's time for public officials to begin caring about the elderly they are evicting for tax defaults.
We appreciate Mr. Phillips' comments with concerns about having to pay property taxes on his personal residence after 65. Proposition 13 limits the property tax increases through having 1% tax rate plus local voter approved debt. And then there's a 2% annual cap established on assessed value increases to the factored base year value. To eliminate all taxes on a particular property for an age requirement would require a constitutional amendment. But since this taxpayer is elderly and age 65, that he may wish to look into the property tax postponement program offered by the State Controller's Office. And we can go to the next comment.
Do you happen to have a contact for the taxpayers that are listening, a direct telephone number and a direct contact that we can give them in the Controller's Office?
Well, verbally, so I mean, we have, all the comments, actually, they don't necessarily indicate that, but
No, I'm
we
asking
can
for,
contact.
if you are able, or a member of your staff could, before this hearing is over, can come back with a name and a telephone number. For those taxpayers that have questions or need to defer their property tax, contact X person,
Yeah.
telephone number in the Controller's Office. Mr. Eppolite, maybe you can help
Yeah, I think
expedite that.
Yeah, we might be able to. It's
Is
a
there something that we
standard
can get done
phone
today?
line for actually the property tax
Excuse me?
postponement. For the property tax postponement, there is a specific section at the Controller's Office, so.
Correct, I
we
know,
could
I know that you
contact
said
them
that.
too.
I'm looking for a person.
Oh, I
I'm
see.
trying to help move this.
I see.
Mr. Eppolite, can you get us a person, get us a contact, a number, preferably a telephone number, an email will also suffice, but just to say, okay, taxpayers, call this person if you have questions in the Controller's Office.
Right, so I'm happy to reach out to myself or one of my staff. We'll reach out to any member who commented on the State Controller's Office about that I'm indicating they might want to explore the State Controller's Office property tax postponement program, so we can give them a direct contact in.
Right, and what I'm asking is before this meeting, this hearing is over, to
Oh,
be
I
able
see.
to do it. I mean, I basically want it
Oh,
now.
I see, okay, well.
I
then,
want it now, Ms. Thompson.
Okay, so maybe.
Mr. Eppolite is jumping on his computer to work on that, and we'll continue with the hearing. And Mr. Eppolite, when you get that done, let us know so you can report back.
That's perfect, and then we can announce that. Thank
One team, one dream.
you. So we can move on to the
next-
comments for number 37. Thank you very
Yes.
much.
The next public comment. I want to remain anonymous. However, I lived in California all my life, and I am 65 now. I am a fifth-generation Chinese American, and my two daughters, both in their 20s, will never be able to live in this state if this tax issue keeps going the way it is.
Oh, I'm so sorry. So we appreciate the comments submitted by Ms. Cum. She described a situation with her daughters never being able to live in the state because of the increase in property taxes. And that is, provisions of property tax law currently. If the children inherit it and one of them do not live in it as their principal residence, and it isn't the parent's principal residence, then it cannot qualify for the parent-child exclusion. So this, again, is a product of Proposition 19, what was voted for, so an amendment would be required. The next three comments, comments number 38, 39, and 40, will also be read consecutively by board proceedings since they are similar, unless the members have any questions or comments on the comments from Ms. Cum.
Let's keep going.
All righty. The next public comment had no name and no location. Prop 19 will hurt our family, and I support repealing it. The next one was submitted by Sherry Silverton from Santa Monica, California. Proposition 19 will hurt our family, and I support repealing it. The next public comment was submitted by Lori Winters from Santa Monica, California. I believe Prop 19 will hurt my family, and I support repealing it. Thank you.
We appreciate the comments submitted by the anonymous taxpayer, Ms. Silverston and Ms. Winters. These comments all indicate Proposition 19 will hurt their families and support repealing it. We do understand the negative impact Proposition 19 has had on families that own rental properties or commercial properties. However, the law no longer allows them to be excluded from reassessment when it's transferred to a child or when the child inherits it. It is real for taxpayers, and we're sympathetic to it. However, it would require a constitutional amendment to allow the exclusion to apply to anything beyond principal residence property or family farm. If there is no comments, we can move to the next comment on comments number 41.
The next public comment was submitted by John Powell from Coulterville, California. Property taxes and bonds attached. Many people have left the state because of high taxes. The bonding companies and the union should not be allowed to advertise in any way to promote bonds. We retired people do not have any way to catch up with dupe the people into voting for a bond initiative to tax us for their benefit. That is very crooked, to say the least. Bonds should also be flat rate since people have equal benefits to the facility being built or repaired. Property taxes are also unfair by using values to collect taxes. Just because I have a higher value than someone else doesn't allow me to larger benefit of any of the use of money. Since I built my home, my own houses with me and my wife, that I am taxed on my own labor. Totally wrong. I'm being punished for working and often priced out of the house I built because I could only afford the materials.
We appreciate Mr. Powell's comments. He believes using value to collect taxes isn't fair. The law in California requires a certain tax rate to be applied to the assessed value of property as determined by the assessor in the county where the property is located. We suggest the taxpayer review our agency's publication 29, California Property Taxes, an overview. And unless there are any comments by the board, we can go to the next written comment.
Let's keep going.
The next public comment was submitted by Laura Ethel from Larkspur, California. Changes to the property tax that do not permit our children to inherit our Prop 13 tax basis unless they make the property their principal residence. These changes are foisted on us by people who distract the voters with sympathy for those whose houses were lost in fires. Our children now cannot afford to live in California unless they are prepared to stop whatever they are doing and move to the family home when their parents pass away. This is wrong.
We appreciate Ms. Effel's comments about the change in law and that it doesn't allow her children to inherit her Proposition 13 tax basis. The law allows the tax basis to transfer if it is the principal residence and it continues to be the family home. So they may want to explore that possibility. And if they want to change the current parent-child transfer exclusion, then a constitutional amendment would be required. Unless there's any comments, we can move to the next comment.
I feel like the next portion of this hearing should be how to pass a constitutional amendment, how to get a constitutional amendment passed. It should be like a kind of a crash course in civics. How to write your elected official, how to advocate on your behalf. Sick and tired of government? Well, let me tell you how to write a constitutional amendment. I feel like people will be running to get into this.
How a bill
workshop.
becomes law. You remember
Yes.
that?
Start singing.
Next
The
comment.
next public comment it was submitted by Carolyn Pico from La Puente, California. Please do not raise our property taxes. We are a low-income couple and are doing our best to keep up with all the expenses we have. In light of the recent inflation, a rise in property taxes would be very, very difficult to survive. Please do not make any changes in the law that will annul Prop 13. This has been a lifesaver for us and for many of our friends as well. Thank you for considering our desperate need. Sincerely, Carolyn Pecco.
We appreciate Ms. Pecco's comments concerning property taxes and ask to not make any changes to law that will be against Proposition 13. Proposition 13 remains in place at this time.
Okay.
And if we don't have any comments, we can move to the next written comment.
Next one.
The next public comment was submitted by Michelle Mojas from San Carlos, California. We have to sell our family home due to the reassessment of property taxes upon inheritance. San Francisco home at 1875 44th Avenue. The date of death value exceeds the Prop 19 reassessment of base value, $50K plus $1 million. Note, this is a very small two-bedroom, two-bath home, considered a starter home. Additionally, Prop 19 rules state that it must be your primary residence. This hindered our ability to keep the property. The fact that if we were to keep it as our primary residence, and if we decided to no longer use it as our primary, we would owe back property taxes based on the value at death. It's ridiculous. Our goal was to keep the property for our daughter to live and attend nearby SF State for college and beyond. Prop 19 made it possible. My husband and I are approaching retirement age, and we could not take the risk of owing back taxes. We're not wealthy individuals. This prop hindered the ability for us to keep the property in the family and have a home for our daughter to afford and live in the same area. It's very unlikely she'll be able to afford a home in the Bay Area. This prop is separating families.
We appreciate Mrs. Mojas' comments. She expresses concerns about having to sell her family house or home because of the property tax increases after she inherited the properties from her parents. The parent-child exclusion appears to have been granted. However, the cap of $1 million plus the factored base year value was not enough, so excess would be added at market value. Proposition 19, as far as the base year value transfer provisions, do have a cap on transfers. So to remove that cap, there would be a constitutional amendment needed. And you see that, we're seeing that in a lot of Bay Area counties and similar with Southern California, high-cost counties. If you don't have any comments, we can move to the next comments.
Next.
The next public comment was submitted by Alice Wissing from Santa Barbara, California. Proposition 19 was created a lot of stress for my family these past 2 months after the death of my father in June. We have been forced to evict 3 renters due to property taxes more than quadrupling. This is because the houses will no longer turn a profit after property taxes and insurance is paid. Rents will need to be doubled in all cases. One eviction is forcing 3 children to be uprooted from the school they are familiar with. This is also forcing a long-term renter of 30 years, a retired individual on fixed income, to find new housing. We also have a primary home that is currently being upgraded so we can charge maximum rent to afford the new property reassessment. What was good enough for our family for 60 years is no longer adequate for people who will be paying market rate rent. In other words, Prop 19 homes will be targeted for high earners. Is this really what our politicians intended when they rushed to place Prop 19 on the ballot back in 2020, when we were hiding in our homes due to COVID? And Prop 19 is not only raising rents drastically, it's leaving families with PTSD after a parent dies. It took over a month to cremate and schedule a service for my father. We thought it would be tacky to place a dumpster in front of his house before the funeral took place, so we delayed delving into the renovation that was desperately needed to afford keeping his house. This created tremendous stress as we emptied the contents of the house into the garbage and patio so renovations could be started immediately after the funeral. Then there is the fear of sentimental items being lost in the chaos as we rush to have an estate sale, all due to Prop 19 bill. We have been denied the ability to grieve. Our lives had been consumed by evicting people as well as emptying the renovating homes as fast as possible. It's dehumanizing. The moderate income families must prioritize finances and business before grieving for parents. This is the new reality that has been created for Californians, and it will be undone as more and more families become wise to it.
We appreciate Ms. Wensley's comments. She expresses concerns about property tax increases on rental properties that she inherited, and was concerned that basically it would reduce profits. Unlike prior law, Proposition 19 did not allow exclusion for rental properties. Only the principal residence is currently allowed, along with family farms, to qualify for the intergenerational transfers of Proposition 19. A constitutional amendment would be needed to change the types of property eligible for the parent-child transfer. Unless there's comments, we can move to the next question, or next commenters.
Next comment, please.
The next public comment was submitted by Aguilar Marie from Gilroy, California. I would like to express my opposition to the death tax. Proposition 19 was misleading for voters. It has forced seniors that I know to take action by transferring their real estate holdings to their grown children, leaving them vulnerable, should their children decide to evict their parents as they no longer hold title.
I'm sorry, can you tell me what the name of that taxpayer was?
Aguilar Marie, or Marie Aguilar, but she submitted it as Aguilar Marie, number 46.
Okay, thank you. So, that one. Essentially, that comment is similar to some of the prior ones, with concerns about the intergenerational transfer exclusions provided by Proposition 19, and any change to allow different types of property would require a constitutional amendment. If there's no comments, we can move on to the next.
Well, before we move on, I want to recognize Mr. Eppolite.
Okay.
Madam Chair, I've gotten the name of the division chief at the Controller's Office that operates the property tax postponement program. So at the end of the day, I'll send an email to Ms. Thompson so she can coordinate that information.
I appreciate that. Thank you very much. And Ms. Thompson, we will have to rely on you and your staff to get to the appropriate
Yeah,
public
we can.
commenters.
Yeah, no, we can do that. Publicly, though, I'll go ahead and indicate that these,
Well, I'd rather just give her the information and then so that way she can then,
yeah, I can just
Good.
reach out to individual taxpayers if that's okay with the chair.
Sure, that's okay with me.
So I'm happy to do that.
I'm glad we got that. Thank
I
you.
just have the name so far and I'll let Ms. Thompson work with her.
Okay, that sounds good. Thank you,
Oh,
Mr. Eppolite.
Thank you. But for other taxpayers that are listening, the State Controller's Property Tax Postponement Program, there is a phone number direct to that program identified on their website. The phone number is 1-800-952-5661, and they actually have an email address as well specific to that, and that is postponement@sco.ca.gov.
Thank you. Thank you.
Excuse
So,
me, if I could.
there's my number.
Oh, Mr.
Could you
Gaines.
repeat it
yeah.
one more time, just for our listeners?
Absolutely. Can we repeat that one more time? Oh,
Thank you.
Ms. Thompson.
So if any taxpayer is interested in obtaining information on the property tax postponement program offered through the State Controller's Office, it is a deferment program for property taxes for those people age 65 and over, disabled, or blind. I think the requirements are outlined online for it, and that meet certain income requirements. The phone number is 1-800 952-5661. And there is also an email address specific to that program, which is postponement@sco.ca.gov.
Thank you.
And I will be, for any written comments that were submitted, that my comments indicated, we suggest they may wish to contact the State Controller's Office. I will personally contact them and give them the phone number as well as the direct contact that Mr. Epelec provides to me.
Thank you.
Okay, so we did number 46. So are we on 47?
We're on 47.
Okay.
Are
The
we
nec-
finished? I had.
No, we're
No,
not finished.
47, we're getting close. The next public comment was submitted by Barbara Bernasso from Sunnyvale, California. Question 1, please clarify the timing of the first phase within 1 year in the qualifying condition number 2 below to take the Proposition 19 benefit. Does this mean the property must become the principal residence of the child or grandchild within 1 year prior to the passing of the family member or within 1 year after the passing of the family member? Including this specific language on the website and other communications will help clarify the timing and not leave any inaccurate inferences to family members. Under the new Proposition 19, effective February 16, 2021, parents and grandparents can transfer their property along with its Proposition 13 base year value to their children or grandchildren, and the following conditions are met. 1, the property must be the principal residence of the parents or grandparents. Number 2, the property must become the principal residence of the child or grandchildren within 1 year, and all applicants must have a valid homeowner's exemption, HOX, filed within 1 year of the transfer in order to qualify for this exclusion. Only the principal residence of a parent or grandparent qualifies for a base year value transfer. Other property, residential or commercial, no longer qualify for this benefit. Question 2, how are families currently made aware of the new Proposition 19 rulings and the need to file homeowners exemption, HOX, within 1 year of the transfer in order to qualify for Proposition 19 benefit? Suggestion, clearly post the Proposition 19 benefit and website information on the property tax bills or on an insert, and request that mortgage companies include the same information on all mortgage bills or an insert. Question 3, are there other logical sources or ways that the state could actively inform families of the Proposition 19 benefits and website? Question 4, is there a Proposition 19 workaround or a way for a family to set up in advance of a grandparent or parent death to transfer title of a property or have inheritors' names on a property title with current family member owners so that the current property value would also transfer and not require new property value assessment and a higher tax rate at the time of the family member's death? The primary residence is still a requirement.
Okay. We appreciate Ms. Bernasso's comments. She asked for clarification on several areas. I'll address the first two first. So one is the phrase "within 1 year" as used in the requirement for the intergenerational transfers. It basically means that the property must be the child's principal resident within 1 year of the date of change in ownership, and that the property must be eligible for the homeowner's exemption. Property tax rule 462.520 does clarify that the homeowner's exemption, if it is not claimed within the 1 year of the transfer, they can still qualify for the exclusion. It is just from the time of the claim as opposed to the date of transfer. Our existing guidance addresses that, as well as the property tax rule, including the emergency regulation that was recently adopted. As to the second question, how people know of the 1 year requirement, our agency has comprehensive information about Proposition 19. We have a dedicated page just for Proposition 19 that identifies pertinent parts about Proposition 19 and its implementing legislation, as well as all guidance issued in that regard. So we have that as well. As to question number 3, they basically are asking, if we could actively inform families about Proposition 19 benefit on it and its website. We do actually have information, again, on our website about Proposition 19. We also have a Proposition 19 fact sheet that we created with the communications officer that addresses all aspects of Proposition 19, as well as the TRA office has published information sheets on each of those provisions. The TRA office is working with the communications officer on getting the word out about these information sheets. We also have been closely working with the Assessors Association in this regard. Prior to the August conference held by the Assessors Association, I reached out to Leslie Morgan to let her know the status of our issuance of the information sheets, so she could spread that word to assessors and their affiliates, and then that would be disseminated down into their staff for notification to taxpayers. So there are many ways for that. As to question number 4, basically it's asking for legal advice on how to avoid property tax increase, which is something we don't do. But they may wish to contact an attorney to discuss, how they're trying to how they choose to transfer title of the property on that. So that concludes my comments. If there's no comments, we can go to the next comment.
Let's go to the next.
The next comment. I'm an SF native.
Is that the 38? We're going to read 38. I'm sorry, I should have said that. So we were going to read 38, 39, and 50 all together.
48, 49, and 50 together.
Or maybe it's 49. 49? Yeah. Hold on one second. Let me see. These comments came in the middle of the night, basically.
Yeah, they did.
So actually, I think 38 separate. Do you have that? 38?
48.
48 separate, and then 49, 50, and 51 are together?
Okay. you
Okay,
could do it
let's do that.
way. Mhm.
Yeah, thanks.
I will read 48.
Thank you.
Public comment. I'm an SF native and resident of SF, never married person living with an elderly parent. The plan was to inherit my house in order to continue living in it. If I needed extra income, I could rent out my home. Because of Prop 19, those plans are threatened. I'm an artist with low income. Upon my parents' death, to be able to afford the new taxes and future property taxes, I will have to go into my retirement savings. That will be exhausted very quickly. I am anxious of my future. There will come a point where I cannot afford the taxes and I may be forced to sell. Where would I go? I can't afford another home in SF. The equipment, vehicles, and supplies for work means I have to have a large living accommodation, so I may be forced to move far away in an area I could afford. Maybe out of state, and my career may not be able to flourish in a new, far-off location. If I wanted to cash out and make millions from my house sale, then great, but I do not want to move. My life is in SF. If I'm forced to sell, I would be removed from friends, family, and clientele I have built up. Prop 19 should be repealed.
We appreciate the comments submitted by this anonymous taxpayer, and with concerns about being able to afford property taxes. They can actually keep, like, the parent's low base year value if it's transferred to a child that continues as the family home. So unless there are any comments from the members, we can proceed to the next 3 comments.
Next 3 comments.
The next public comment was submitted by Jim Louie. Prop 19 is the most deceptive tax law ever passed in California. Completely funded by the California Association of Realtors, ostensibly to help seniors, wildlife victims, but in reality works to force sales of homes so as to profit the industry. This law basically takes money from those who have already lost loved ones by taxing their inherited properties at market value to pay the beneficiaries. Because of the high value of homes in California, the higher property tax benefits the state as well. Since most who inherit property will not be able to pay the extreme high tax, they are forced to sell the property, benefiting the real estate industry. I can assure everyone these special interest groups do not spend millions to promote a law so it can benefit the elderly and wildlife victims. This law will force many families to leave California and break up generations of families who otherwise would have stayed. The group most harmed will be middle-class families. This law will not only harm property owners, but also renters, as landlords are forced to increase rent to pay for the higher tax. California is already an unlivable state due to the high housing costs. This law will do immeasurable harm to the citizens of the state. While the BOE has no authority or say in this law other than to do its best to interpret the law and implement it to the best of its ability, it is a sounding board for citizens to raise concerns on tax matters. In this regard, I hope my concerns are heard and to wake up all those who are unaware of the consequences of this law. I hope the state agency will conduct a post-implementation impact of this law and expose the harm this deceptive law has done to families in California. We must also stop special interest groups from creating and promoting such laws where the real beneficiaries are those from this group. The next one is submitted by Becky Lee from San Francisco. Most of us have no idea when Prop 19 passed. How harmful are children when parents pass away. Our children cannot afford to pay the huge increase in property taxes after parents' death. I strongly voice out to reinstate Prop 58. Property owner should have the right to rent the property or not. Oppose vacancy tax unfair to property owner. And the next one is Ollie Ludwig from Capistrano Beach, California. Prop 19, related tax increase. Shocking 1,000+% year fiscal year increase seems fundamentally disconnected from how home economics function. So much for 30 years of careful financial planning.
Is that it?
That's the 3 together, yes.
So we appreciate the comments submitted by Mr. Louie, Ms. Lee, and Mr. Ludwig. They all express concerns about Proposition 19 or disagreement with it. To change the provisions of Proposition 19, it would require a constitutional amendment. So we suggest that they contact their legislature. If there's no comments, we can move on to the comment for number 52.
The next public comment was submitted by Carol Hamberin from Whittier, California. I am appealing for a provision rider or to be grandfathered in to Prop 19 for helping me as a 78-year-old low-income elderly to stay in my home, to transfer my base value property tax to my new condo as of July 2020, when I was and have been on Prop 13 since 1980. I was given different information from speaking to various representatives since I began calling and writing letters to the LA County Tax Assessor and to his office, as well as the BOE. It is my understanding that my letters were not given to Mr. Prague, but instead distributed to others. Those others people were telling me not about a purchase date after April 1st, 2021, but to fill out an application after April 1st, 2021. I have been asking about this issue for approximately 2 years now. Please help me out. I was furloughed out of my substitute teacher's position in March 2020 due to the COVID-19 pandemic, and we had to move back to Whittier in July 2020. The voting ballot for Prop 19 was confusing, and no date was given for the purchase of a new residence. We are on the SNAP program, the CARE program, the LIHEAP, and inflation is barely letting me pay my expenses. I need to be near my doctors because I have COPD, osteoporosis, and have battled breast cancer since 1984. Please make a provision for me. I am now awaiting the decision on my appeal. If the reason this Prop 19 was to help the elderly with health conditions, especially during the pandemic, who had to move because of finances, then I am asking for a transfer of tax base for not 3 times as proposed, but 1 time. Governor Newsom, in his Master Plan for Aging, executed Order N-1419 for state government, local government, to implement strategies that promote healthy aging and, as we face uncertainties, including issues like healthcare, housing, and overall services, to take care of the older Californians and not to deny them the dignity of staying in their own homes. This is straight from my readings from the various executive orders that our governor has ordered. Please help me.
We appreciate Ms. Hambarian submitting comments. The TRA office worked with this taxpayer on several occasions. She applied for a base year value transfer on her home to Los Angeles County before the effective date of Proposition 19's base year value transfer provisions, and was denied the base year value transfer. It was denied because she already used her one-time base year value transfer previously when she transferred the base year value from a Los Angeles home to her former Orange County home. So we explained that the law prior to Proposition 19 was such that a base year value could only be transferred once for age, and if she did meet the qualifications as a permanently disabled person, then she could apply under that condition, under 69.5. We explained that she could still qualify for a base year value transfer if she purchased another home and then transferred the base year value to it from the Orange County house, as long as it was within 2 years of the sale of her original home. When the taxpayer contacted us initially, there would have been time to do that, but this taxpayer does continue to contact us. Unfortunately, she purchased a home before the April 1st, 2021 effective date for Proposition 19's base year value transfer provision, so she wouldn't be eligible to have the base year value transfer because she had already used it previously to that particular house that she bought in Los Angeles. And Ms. Hambarian's comments indicate that she's had issues for 2 years. We do know that the assessor's office in Los Angeles responded to her on several occasions. So that has been responded to. So unless there are any comments, we can move on to, I believe, the last comment.
The last comment for property taxes, yes.
Oh, yeah.
This public comment was submitted by Turi Altavia from Los Angeles, California. Prop 19 should be repealed. It has harmed my family in ways we are still dealing with.
We appreciate Tori Altavella's comments. Similar to what other people expressed, she wants to repeal Proposition 19. And again, our agency does not have the authority to repeal Proposition 19. That would require a constitutional amendment. So they would need to contact their Assembly and Senate people, or also potentially look into whether the Howard Jarvis Taxpayers Association is putting forth another measure for the ballot. That concludes the comments for the property tax portion of it. So.
Thank you. I have a question. Mr. Gaines, I'm going to put you on the spot here. You are a retired state senator, also spent time in the Assembly too, is that right? So could you advise some of the folks that are listening or watching today's hearing, and we have said time and time again, you need to go connect with your elected representative and your member in the legislature. But what's the most effective way to get the members' attention? I have heard from taxpayers, they have said to me, well, we've tried, but we can't get a return call, or we can't meet with the member themselves. So in your experience, maybe you could share with us an effective technique.
Yeah, well, almost all of us are elected, and
Yep.
I mean, we're elected here, but we've been elected.
Speaking to the mic.
We've been elected to other positions, and certainly constituents who are calling and writing letters catch the attention if you're a member of the Assembly or the Senate. And there's a pathway to resolve this, and that would be through a constitutional amendment. It's my
There's two pathways, basic, right?
Yeah.
Constitutional amendment and
then a ballot initiative.
ballot of initiative.
Right? So the constitutional amendment, my recollection is I think it's 2/3 vote in both houses, and then it goes on to the ballot for a vote. And I think it's just going to take a lot of people speaking to their elected officials, and they probably ought to organize into some sort of group that can be effective in communicating with their legislators and basically saying and telling their stories. We heard so many stories today of how sad stories about how people are impacted, that they would then take action and put this back on the ballot with either repeal or reform, right? It could go on as a referendum to eliminate it, or you could reform it, just make changes to it that resolves the challenges that we keep hearing, really, meeting after meeting for over a year now, right? So I think those are the two pathways. If you go the ballot measure, it's pretty daunting because it's expensive, and if you have a huge grassroots effort, you might be able to get away with spending a few $1 million, but we've heard of initiatives that have cost $100 million also. So it just depends on how active and organized people are. And I think, you're saying, well, how many people are impacted a year? I think it was the LAO that said 40 to 60,000 a year. But that grows every year. And so you have more and more people finding out about the initiative and the negative impacts that it has. And I think it's really critical because it was brought up that, we lost a congressional seat. We've had people leaving the state of California for various reasons, but I think a lot of it is driven by economics, and people just can't afford to live here, or maybe there's other job opportunities. But we may be piling on with the passage of Prop 19, more and more people forced to make a decision in terms of where they can live for less cost and actually moving out of the state. And we don't, that won't happen for another 10 years because we do the census every 10 years in terms of determining how many congressional seats we have, but it can't be helping it. So my hope would be that there would be action in the legislature. And if that's not happening, that we'd take a look at this ballot initiative. And I support both of those pathways, whatever I could do to help my constituents in that effort, I will do. But it's a big challenge, and people didn't have all the facts. We could use some reform on the ballot title and summaries also, so that it really ought to be looked at. I don't know, you could get retired judges, set up some sort of committee that would review these things on a nonpartisan basis, so that they would just be accurate, so that people would understand when they read their ballot exactly what the impacts are going to be. So.
Thank you. I think that's
Yeah.
helpful. Is
Thank
that
you.
helpful? Okay, good. All right. Ms. Cicchetti?
Yes.
Please call the next item.
Yes. The next two items that are written public comments were on the alcohol tax.
Yes.
The first one was submitted by Jonathan Green. I feel that alcohol illegal to use to drive or cause injury in self the wrong way. Why pay for it for an individual who does not drink? It's disrespectful as well as not fair. I'm paying into from my impound for mortgage for those who get drunk like it's no care in the world. I should only be taxed by business where if an individual buys alcohol, drink. Put more tax for them to pay, not all who have house mortgages.
We appreciate Mr. Green's comments. He seems to be concerned about charges for the alcoholic beverage tax. The alcoholic beverage tax is not a tax on the consumer. It is not related to a mortgage impound account. The alcoholic beverage tax is a per gallon excise tax paid by companies or people that distribute, manufacture, or import any alcoholic beverages, beer, wine, distilled spirits. So unless there are any comments or questions from the members, we can read the next public comment.
Next comment.
The next comment was submitted by Chauncey McKern, Managing Member, Santa Monica Mountains Farmstead LLC from Thousand Oaks, California. Number one, alcohol taxes. The federal government, TTB, charges taxes by proof gallons, but California charges taxes on the entire beverage by wine gallons. So if we make a drink that is 10% alcohol and 90% water, California taxes the whole drink, including the water. It would be best if alcoholic excise taxes were abolished altogether and just taxed the drinks with sales tax at the end buyer. If that can't be done, at least use proof gallons to match that the TTB does. Number two, California business taxes are exorbitantly high. We run a craft brewery and probably have to maintain 20 different permits. They all cost a lot of money, for which we get almost zero benefit, and many of the California taxes, including the California business income taxes, are based on gross sales rather than net sales. So even if we don't make a penny in profit, as has been the case during most of COVID, we still have to pay taxes on approximately $500,000 in gross sales. Number three, California property taxes are outrageously high. I worked all my life to buy a 47-foot sailboat and have to pay approximately $8,000 property taxes for it every year. But I don't get any more benefit out of the marinas or waterways than a sailboat that cost only $300, or even the people who just come for the day and put their small boats in the water. There's no logic to charging by the value of the boat or other property when everyone is getting the same benefits or no benefit at all. Number four, automobile registration fees are exorbitant. I have a 2017 Ford F-250 pickup truck, and it cost me about $735 to register it this year in California. I have a West Point classmate that lives in Georgia with exactly the same truck. It cost him $38 to register his truck, and when he went to the Georgia DMV, they said he wanted to register his truck. They told him to have a seat. Before he could get to his seat, they called him to the counter for service and said their goal was to serve at least 94% of the customers before they sit down. You could spend half a day at the California DMV before getting to the counter, assuming the DMV is even open that day, and the folks there don't seem to give a damn about serving you. We need an attitude check at the DMV and the entire California government. They've forgotten who they work for.
We appreciate Mr. McKern's comments concerning the various taxes. With respect to the alcoholic beverage tax, he expresses concern about California excise tax for wine and alcohol and the amount of tax charged per gallon. I'd like to be clear that the alcoholic beverage tax is not a tax charged to consumer, but rather a charge to distributors, manufacturers, and importers of alcoholic beverages. The type of alcohol, including beer and wine, as well as that is the rate, is stated in the Revenue and Taxation Code. To change the per gallon tax rate, it would require a statutory change. With respect to the second concern about business taxes and maintaining numerous permits that are costly, we are aware that the California Department of Alcoholic Beverage Control does charge fees for licenses that they issue to companies to sell, distribute, and manufacture alcoholic beverages. But as far as having an account for the alcoholic beverage tax with the BOE, we do not charge to have an account, nor does the California Department of Tax and Fee Administration charge to have a sales tax account. Should Mr. McCarran's brewery sell it to consumers. Local business licenses from local city and county may also result in costs. Any permit or license fee for his company or himself that is being charged is not from our agency. As to the third concern about property taxes and paying $8,000 for a sailboat and not getting any more benefit from the waterway than anyone else, personal property such as a boat is taxed at market value as of the January 1st lien date each year for property tax purposes. Any change to that would require change to the to the Revenue and Taxation Code. However, given that he said the property taxes each year was $8,000, it may be that he's also being assessed a possessory interest for the use of a marina slip to a dock that his boat is in the bay or an ocean somewhere due to the use of government-owned property. Otherwise, with an $8,000 property tax bill and the 1% tax rate, that means the boat would be valued about $800,000. So, he did say the sailboat was 47 feet. I can't indicate the value of a boat. Maybe it's a really nice boat. As to the fourth comment, as to concerns about automobile registration fees, those are not within our agency's jurisdiction. And that concludes the written comments for the Bill of Rights hearing.
Thank you.
The last part of the Taxpayer Bill of Rights hearings is that we're going to go to the AT&T moderator for anyone who'd like to make a public comment using the AT&T line. AT&T moderator, please let us know if there's anyone on the line who'd like to make a public comment regarding the Taxpayers Bill of Rights hearing. AT&T moderator? Let's see if we can find out what's going on. He's typing, yeah. We're seeing if we have an issue.
Okay.
Chair Cohen,
Yes.
one of the options we can do is we do have an public comment. We can take the additional public comment for the Bill of Rights hearing at that time if you want to move on with the calendar for now, if we can't establish contact with AT&T at this point.
Sure, and we're not relying on AT&T.
It seems to be an issue with the auditorium and not the AT&T moderator is there. Everyone could hear it actually on the public line. We
Okay.
cannot hear it here in the auditorium, so we're
Okay.
trying to find out what's happening.
Okay. Okay, well,
Mary,
we
do we know if we have any speakers?
We'll ask.
Yeah.
Thank you.
Great.
Just a second. You have a question for staff?
For Lisa.
Oh, Lisa Thompson, one of our members has a question for you, Mr.
Certainly.
Schaefer.
Ms. Thompson, I'm very impressed how thorough a job you've done, and our anonymous and our non-anonymous people, and did appropriate combinations, which saves us time and gets a good answer for everybody, because we encourage everybody to come forward. I just assumed until today that my little packet here included copies of the input, and that's a general statement, but not a complete statement, because there are people who come in all night long, as you point out, and we do receive them, and I applaud you for doing that. But I'm not aware that when you're reading somebody from my district, that, gee, I'm going to want to see what they had to say and maybe take a special note to see they got well served. I can't find anything. I was able to find David Frankville, of course. He just finished. David Prento, specifically of my district, I spent 20 minutes going through the file and couldn't find him. And Barbara Benanco, who is concerned about when residence is timed, I spent a lot of time going through the documents here and can't find it. Where do I go to get that? You have that?
So the board proceedings section actually has that, and so they do provide those to members, but each of the public comments will be posted to the board proceedings page under the public comment area as well. But as the comments through, as I understand it, sorry if I'm speaking for you, as the comments come through, then board proceedings will supply them to the, or distribute them, I guess, it's to the members. So obviously, when it happens, you know, at 1 a.m. or 3:46 a.m. in the middle of the night, last night,
Yeah, we
that's a
did-
little more challenging.
We did distribute the public comments that we had in writing yesterday to a certain point to get them to the members at the close of day. We had many of the public comments came in between the close of business yesterday and what we could say midnight, 1 o'clock. And so all of those are being uploaded onto our webpage so that they will be a public comment. You'll be able to see them on the webpage and the public, and they will be distributed to you as a total package to your office directly. So you'll be able to have them all.
I'm just interested in seeing what the good people in District 4 are saying when they talk to us, and I generally take notes, but I know if I have something here, I'll take less notes and do some more reading.
Yes, you will have them.
Thank you.
They
I-
will be
Thank you.
available.
Thank you both.
I have a question and a comment for Ms. Thompson, if you don't mind, as you continue to work out the details with.
Yeah, we think it's fixed, so we
Oh,
could.
okay, well then let's go ahead,
Let's
wrap
try
up
him.
public comment and I'll make my
AT&T
comments.
moderator, do we have anyone on the line who'd like to make a public comment regarding this item? Taxpayer Bill of Rights hearing? Well,
This is AT&T. Can you hear me?
yes, we can hear you now. Thank you. Is there anyone on the line who'd like
Perfect.
to
We have
make? Okay.
we have a comment from Ollie Ludwig. Please go ahead.
Thank you.
Can you all hear me? Is that enough?
Yes, we can hear you. Please proceed.
Okay. Can I still make a comment about the Prop 19, or am I off topic?
No, you're not off topic. You may make a statement.
Okay. Thank you so much. I wanted to just say thank you for giving me the opportunity to speak. I wanted to take a step back. A couple of speakers earlier spoke eloquently about, you know, parents turning over in their graves. I just wanted to make my comment as if it were my late mother making the comment. She died 12 days after that February 16, 2021 deadline, after an arduous 5 years with Alzheimer's. Now, if I'm going to talk about my mom, I should let you know she was about as democratic as they come. She would have been happy to pay more taxes. But what we got from the assessor 3 weeks ago in Southern California in Orange County, 1,800% increase in 1 year over the next. I mean, let's be honest. If I walked into the boardroom of Aetna Incorporated, PepsiCo, Microsoft, even private companies like Bloomberg, LP, or Bechtel or something, any industry, you walk into a boardroom and say you're looking at an 1,800% tax increase, they would escort you out with security. Say, get the heck out of here, you joker. I just wanted to make the point that my mother would have been happy to pay taxes. And if she wasn't so depleted from Alzheimer's, on November 4th, she would have stopped eating because she wanted her children to enjoy her home. She would have stopped eating, but her mind was gone, and she wouldn't have been able to do that. I mean, she was an observant Catholic, very, very fiery in her way. I'll bet if she were still in top form, she'd be up in Sacramento, and Governor Newsom would probably know her by her first name. She was that kind of person. She came here from France after marrying a German man. Imagine that, a French girl marrying a German guy, comes to the States, loves America, loves California. I'm barely holding it together, ladies and gentlemen. She loves America, she loves California, raised 4 sons, wanted to leave behind her little slice of the American dream. Guess what? 1,800% property tax increase 1 year over the next? Looks pretty iffy, I'll tell you that. Looks pretty iffy for my family. We are all crushed. Crushed. Again, imagine I'm Francine Ludwig doing the talking right now, not Ollie Ludwig, her youngest of 4 boys. We are crushed. And we would happily pay more taxes. But 1,800% year over year? I mean, this is a dereliction of legislative duty. Pure and simple. Our hearts are broken, and thank God my mom can't turn over in her grave. I hope she's in heaven looking down on this and just scoffing at the Assembly and the Senate and the governor. And by the way, I know you people on the board, thank you so much for letting me speak, but I know you say this is a duly passed initiative on November 3, 2020. I beg to differ. I think that's extremely generous. COVID-19, an absolutely upsetting election cycle in 2020 in so many ways, whether you're a conservative or a liberal. And then think about California just engulfed in smoke for much of the year. People were freaked out. The last thing they were thinking about was this. So I would implore Californians to sign petitions. I would implore legislators to turn this around. This is wrong. Again, my mother would have loved to have paid more taxes. She loved California. She knew it wasn't for free. But let's be reasonable. That's really all I have to say. Thank you for indulging my impassioned and possibly reactive words, but this is my mom talking, who's looking at us from above, shaking her head, because she was a fiery French girl who loves America. Thank you so very much.
Thank you.
Thank you.
So we appreciate Mr. Ludwig's comments. We are sympathetic to his comments as far as valuation increases. We're not sure if the property was his mother's family home or if it was a rental property. But, you know, if it was her family, if it was her principal residence before she passed, the children would have been able to keep the that, you know, lower Proposition 13 factored base year value if one of the children chose to live in that home. So it would continue with the family home, but we don't know the situation, with that. However, if they chose not to live in the family home within a year, or it was a rental property, then the property tax law would require it to be reassessed at market value. And, certainly 1,800%, like he indicates, is high. But as you know, market values of real property, especially in Bay Area and, Southern California beach counties, are high right now. And, if she in fact lived in the home for, 30 years or so, or plus years, and had, really low property taxes, probably we're looking at, $50,000, $60,000 assessment before she passed. And that would increase at that point. So, again, we do appreciate it, just as we appreciate any other taxpayers' comments about the intergenerational exclusions and the Propositions 19's impact on it.
Thank you.
We have another person on the line. AT&T moderator, is there any additional persons who'd like to speak on this matter at this time?
Yes, Barbara has a comment. Barbara, your line is open.
Hello.
Hello?
My name is Barbara Bernasso, and I had made the suggestion that the BOE actively makes efforts to inform the public that an HOX form must be filed to even request the Proposition 19 benefits. And the answer was given that a dedicated page exists. But I want to push back a little bit and say that people don't even know that they may need to seek out a dedicated page for this information. They may not even know about, even the ability to have this intergenerational property transfer. And I would just request that the BOE actively and transparently markets this information so that the public is aware of the Proposition 19 requirements. And my second real quick request is I'm just confirming the response to my first question about the phrase in the qualifying condition number 2, where I say within 1 year. So the HOX within 1 year has to be submitted within the date of transfer, was the response given me. When do you legally consider the date of transfer of the property? Is that at the date of death or the date the trust is implemented? When does the clock start on that 1 year time frame to get that HOX document into the board?
Right, so I'll be happy to address this. This is Lisa Thompson, the Chief of the Taxpayer Rights Advocate Office. First, in my comments, if I maybe, I'm sorry if I was misunderstood, but I didn't say that the homeowner's exemption had to have been claimed within the year. I indicated that the property needed to be made essentially the principal residence within a year. Proposition 19, actually, the language in that, as well as the implementing legislation, does talk in terms of the homeowner's exemption being essentially eligible for the homeowner's exemption, and it must be filed within 1 year. However, our property tax rule has clarified that such that it should be filed within a year. But what it accomplishes, it basically says it doesn't eliminate from qualification for the parent-child transfer if it goes beyond that year. So I'm happy to reach out to you separately to go over a little bit more information on this. But basically, the date of transfer is considered, say, if you transfer the property, it's within the date of transfer. But in the case of the date of death, it is the change in ownership date. So that is the date. So it would have to be within the date of death if, in the case of inheritance, in that regard. So we are, again, you indicated marketing information kind of so the public is aware of, Proposition 19 and its provisions as well. We are, the communications officer and I are actively reaching out to different stakeholders to kind of publicize that more. In addition to that, I think I know what you're meaning. You're meaning that taxpayers maybe don't even know that they have to do it. So I think the key is to get more information out on the requirements of a real property owner when the death of a real property owner dies. So basically, people know they have to do certain things. You've got to file a change in ownership statement with the county assessor's office to advise them of a death. Record an affidavit of death, and then also, if you're interested in getting the parent-child exclusion, think about who's going to move into there if that's going to be one of your options to file a claim. So that is one of the things that the Taxpayer Rights Advocate Office is working on, where we have a series of information sheets that provide information to taxpayers in simple, non-technical terms, so they're aware of property tax savings that may benefit them. We've just finished a series of information sheets. We've issued 6, all having to do with the intergenerational transfer exclusions and base year value transfer exclusions under Prop 19 as well as prior law. And after those are all posted, we will be continuing with information sheets on our plan. One of those items will be an information sheet addressing things to do, things that are kind of required when basically the owner of real property in California dies. So that way it's readily available to taxpayers. But many county assessors' offices have information about that, what happens, and what your obligations are when a real property owner dies. So we'll be happy to do that. And I'm happy, again, to reach out to you separately, to kind of direct you to those resources. But it is in the property tax rule 462.520 that talks about the filing requirements for the homeowners.
We're here.
You could ask one of my staff members in the audience. Ms. Thompson,
Yeah.
does that conclude your
That
comments?
concludes the comments, yes. Thank you.
All right. All right, Mr. Keddy, how are we doing on the call line?
No other callers on this matter.
Okay, great.
So
I
this
have,
can-
I have a question for Ms. Thompson.
Okay.
And then we'll keep moving, because we have still a lot of agenda ahead of us. So thank you for your presentation today and for another successful Taxpayer Bill of Rights hearing. I think this is the best one that at least that I've participated in. Good job.
Thank you.
With the outreach, good job answering the questions real time, collecting the information, spending the time to analyze them. I mean, it's fantastic, Lisa. You definitely have just risen to the occasion, and I'm really proud of you.
Thank you, I appreciate it.
Yes, absolutely. I also have appreciated this unique opportunity to provide taxpayers a venue, a forum to hear from them. And it's no surprise that there are a lot of frustration around Prop 19. We will continue to do our best to educate, to get information out there, and be supportive to taxpayers as much as possible. I want to call something that I've noticed in the annual report, that the TRA office handled 232 new cases. This compares to handling 250 cases in the previous fiscal year. And this figure around 250 has held steady for several fiscal years, so it sounds like we're on par. We're doing good work. I believe more taxpayers would take advantage of our TRA office if they were aware of the services offered. And I feel like we heard that in just the last comment from the public commenter. We just got to continue to let people know. Each county has a taxpayer advocacy office, and Ms. Thompson just happens to be here in Sacramento running the entire operation across the entire state. Is that right?
No, we just help, we
You
help
just help, okay.
taxpayers throughout the state. So, so we provide services to any taxpayers in any one of the 58 California counties, so yes.
Fair enough. So colleagues, I previously suggested that we consider reaching out to the California Association of County Treasurers and Tax Collectors to explore placing an insert in property tax bills. An insert into property tax bills, notifying taxpayers about our TRA office and the services that we offer and that we share. I think it's one way that we can effectively communicate with taxpayers directly and might minimize the information gap. To move the suggestion forward, I sent a letter to Ms. Shari Friedenrich, who is the president of the California Association of County Treasurers and Tax Collectors, requesting an opportunity to discuss a partnership. If you don't have a copy of the letter, I'm happy to furnish one for you. I will update you at our next board meeting on my progress in my conversations with her. So, but Ms. Thompson, my question to you relates to informing taxpayers about how to complete the parent-to-child and grandparent-to-grandchild transfer under Prop 19. And I see that there's a Prop 19 fact sheet that's located under the sublink entitled Additional Resources on the BOE Prop 19 information link on the website. But my concern is that this form, my concern about this form is that it provides substantive information, but it doesn't provide a step-by-step review of what taxpayers need to do to obtain the valuation exclusions under Prop 19. So my question is whether we can do a step-by-step guide on receiving property tax valuation exclusions under Prop 19. And we will help to move this conversation. I believe such a forum could be very helpful for taxpayers and could provide additional clarity for taxpayers navigating the changes created by Prop 19. Do you have any initial thoughts?
Well, I do. So I think, thank you for referencing the information sheets that we have out there, and they do, again, provide helpful hints about them, the basic requirements, main requirements, where to find resources, helpful hints in that regard. But as far as how to, to doing a step-by-step on what to do to get the exclusion, that kind of sounds like legal advice. So, I mean, you'd have to be I think that'd be pretty difficult to do, because we don't give advice on, like, how to transfer property and how to hold title and how to advise it. It's more of, we're telling them this is available, and what the qualifications are for that. And really, it's the taxpayers or their attorney's job to figure out, if there is a way, say, to structure a deal, a real property transfer that might mitigate some property tax increases.
Okay.
And in light of, with counsel that they're seeking, to see what the repercussions are for other taxes, because people don't, or they shouldn't necessarily, make decisions just purely for property tax purposes. There's a whole different world out there, income tax purposes. So, that's why they do that. We would be careful to say, well, this is how you should do it. That would be kind of like saying, you should, this is what you absolutely should do to get property tax savings. But on the other hand, then, we're also not telling them about other taxes that they might be losing out on, like income taxes.
I see. And maybe what we could do is try to work out the kinks. I don't know if I'm necessarily communicating this thought correctly with you.
Oh, okay.
And we can talk a little bit more with counsel.
Of course.
And then come back and report out. But what I'm thinking is you need to have these documents in front of you. You should maybe talk with your tax preparer, and maybe how to form, not necessarily saying if you want relief from this tax burden, this is what you need to do. I'm not asking you to hand over the keys to the kingdom, if you will.
Thank you.
But maybe providing a little bit more context so that the conversation is so that the paperwork is easier to understand. Basically, so a person with maybe about a 5th or 6th grade reading level, they'd be able to understand some of these forms. And ideally, they should be able to fill out these forms without hiring an attorney.
Sure.
Because that is not everyone has that privilege. So, thank you. We are going to keep moving forward. And Yvette, do you have something you want to say? Ms. Stowers is coming to the microphone.
Thank you, Madam Chair.
Yes.
Thank you, Lisa. Very quickly, your request is something that we are currently working on.
Okay.
Member Vasquez asked for it last month.
Okay.
And we didn't understand what he was asking for, but after further talking to him, we are putting together a checklist to say, fill out this form at this time in this form.
Thank you. That's
And we will market that as well.
All right. So I hope to be able to get that checklist and get some more clarity, get the information out there, because we know that when that legislation was passed, there was trailing legislation to help with the implementation of it. So there's still a lot of loose ends that we are finding. Ms. Thompson, you did an excellent job today. You should
you
feel
so
good
much,
about your
Member
work.
Collin,
You and
I
your
appreciate
team,
it.
my highest compliments to you. Colleagues, are there any, Mr. Gaines has something, anyone on this end? And then Mr. Vasquez. We'll go to Mr. Gaines and Mr. Vasquez.
Thank you. I want to thank Lisa Thompson for a great presentation and a lot of good input. And we take a look at Prop 19 and the challenges that we've had for a long time since its passage, and a lot of concern on the death tax aspect, I would like to make a motion that the BOE would sponsor a constitutional amendment to fix Prop 19 by eliminating the death taxes that are within it. And I think we could take action as a board and work with the legislature for fixes. And so I'd like to just present that and ask for your consideration, because the impacts are real, and we keep hearing story after story after story. And I know that we have to administer Prop 19 as it exists, but if we could take a leadership position in, working with the legislature, asking them to take a look at it, and let's figure out the fixes that that will provide relief for homeowners that are getting hurt so terribly with the taxes that are being
Well, let's see
put
what
upon them.
our legal counsel has to say.
Okay.
Thank you, Chair Cohen. Thank you, Member Gaines, Vice Chair Schaefer, and honorable board members. Unfortunately, it would not be appropriate for the agency as a whole to sponsor a constitutional amendment. All due respect, the members as elected officials, that's something that your individual offices can do. So I just want to be mindful and clear that we as an agency cannot participate in that effort, but you as individual board members, obviously, that's within your right.
So we don't have a right to weigh in on issues as a board, as an elected board?
The challenge is we as an agency, speaking on this side of the board, for lack of a better term, my apologies, can't participate because we are an agency to administer property tax, you know the standard there. You as board members, I would recommend that you just be mindful. I don't know if there may be FPPC concerns from an individual basis for you, so I would have to look into that some more. I have not looked at it from that standpoint, but I just wanted to kind of advise the board that we as an agency unfortunately can't participate in that effort.
All right, but you as an individual would be able to move forward.
Right.
So it sounds like that motion doesn't have a second.
Yeah, okay.
But it also sounds like there is room for more conversation
Right.
to look for look what kind of to explore what kind of action can be taken.
Okay.
Mr.
Chair Cohen, I was of the opinion that the BOE as an agency supports or opposes legislation all the time.
That's a good point. Let's let our legal counsel explore a little bit more and come back to us, because but you're right, we do write letters in support of bills, and mostly things that are moving its way through the legislature. I don't think we've ever taken a position on an item
Okay.
that's been going to voters. We as individuals have, but not as a body. So we should definitely look at the,
If we could explore it in terms of what we can or cannot do, I think it's something that resonates very clearly, and I'm just trying to figure out, where's there a pathway where we can try to help folks out? So,
thank you.
Chair Cohen, members of the board, again, we can explore that a little further to Member Schaefer's, Vice Chair Schaefer's point. If you remember, the letters of support and things of that nature have been by the board members as a board, but not the agency. The agency is a state agency. We're limited on what we can do along those lines. But I can have my team do some more research and see what is there. But again, Member Gaines, as you eloquently put, where you eloquently described the three methods by which a repeal of Proposition 19 could occur. I mean, those are the same methods. Whether or not, to what extent the board members may participate in that or help lead that charge, so to speak, it requires either going to the legislature, doing an initiative, or, from that standpoint. So it's just to what extent does you as individual board members want to participate in that process?
okay, but I thought Member Schaefer brought up a good point in terms of at least, because we've weighed in on legislation that's moving through the legislature, so it'd be nice to have clarification as to why we can do that, but not support an effort to exact change on a
Yeah, and
proposition.
I know there's a distinction, but I'll do more research on it and give you a little
Okay.
better information on
Okay.
this. And I also want to be careful about the fact that this is not agendized, so we need to, I'm viewing this as spirited conversation and a conversation that resulted from some of the feedback that we've heard in the TRA Bill of Rights hearing, which is appropriate. But again, because this is not agendized, let legal look
Okay.
at it, and we'll come back to you next month.
That's great, thank you.
Thank you.
Mr. Vasquez.
Yes, I'm definitely interested in that, if that's a possibility. But it's my understanding, I think, because we're not the legislative body, we can't initiate it, but I think we can support it once we get a legislator to move it, I think. But let's see what happens. And I just wanted to add my thoughts also and my praise to you, Ms. Thompson, and your staff for the great job that you've been doing and that you presented today. And I know you've been very helpful to my office when we've gotten a lot of constituent calls on a lot of these issues, mostly around Prop 19, where you've been able to navigate that because you're right, every case is kind of a special case because there's so many nuances to it, like you mentioned earlier, especially on the issue of, joint tenancies and those type of things that are happening, and trusts and LLCs that people have with their properties. So just wanted to give you my kudos and thank you and your staff for all the work you've done.
Thank you. Thank you, members, for your kind words. As we conclude the Taxpayer Bill of Rights hearing, I just would like to thank my team in the TRA office for all of their hard work that they do. I really appreciate it.
All right, thank you.
Thank you.
Okay, folks, it is almost 3:30. I want to check in to see if anyone needs a break. Yes, we're going to take a 10-minute break. Thank you.
Thank you.
Yeah,
So they're
yeah.
not going to show up.
Sure, sure, sure.
All right, good afternoon. We are going to reconvene. It's 3:45. Ms. Cicchetti, could you call the next item? Thank you.
Yes, I can. The next item is G1, rulemaking, proposed property tax rule 462.520, staff request for authorization to publish amendments to property tax rule 462.520, exclusion from change in ownership, intergenerational transfers, and to certify amendments previously made via the emergency process, making them permanent. This matter will be presented by Mr. Moon virtually.
Great. Mr. Moon, good to see you this afternoon. Thank you. When you're ready, you may
Good
begin.
afternoon. Good afternoon, Chair Cohen, members of the board. My name is Richard Moon, and I'm with the legal department. As you know, since the passage of Prop 19, staff, along with the CAA, have been working to provide guidance for its administration. The approval for the publication of the amendments to Rule 462.520 covering the intergenerational transfer portion of Prop 19 is before you today and is a continuation of that work. These amendments were put out for comment, and any accepted amendments are reflected in the version of the rule in front of you. Staff requests that the board approve the publication of the Notice of Proposed Action for the Certificate of Compliance and Regular Rulemaking Process for Rule 462.520. Should the board approve staff's request, we would plan to hold a public hearing at the November board meeting, at which time the board would have the opportunity to hear public comment and vote to adopt or not adopt the rule or to make any changes the board felt necessary. Thank you, and I'm happy to take any questions.
Well, thank you. That was quick. Thank you. Members, do you have any questions or comments for Mr. Moon? All right, seeing none, let's take public comment.
AT&T moderator, please let us know if there's anyone on the line who'd like to make a public comment regarding this item.
Thank you. Once again, ladies and gentlemen, if you do wish to make a public comment, please press 1 then 0 at this time. We're going to go to the line of Barbara Bonasso. Please go ahead.
Hi, this is not relative to what you just spoke about, but it's something else regarding the step-by-step process of what documents need to be sent in to apply for the Proposition 19 benefit. It was very clearly listed on the Proposition 58 form, you know, the death
Ms.
certificate.
Bonasso,
trust, will,
excuse me, Ms.
etc.
Bonasso, can I interrupt? We do have an item on the agenda where you could make a comment that's just a regular public comment on an item. We're actually talking about this one rulemaking process at this time. We plan on getting to that item in the near future. If you wouldn't mind just staying on the AT&T, and we'll call you at that time.
Sure, T&T rep wasn't real clear as to if I should interject. Yes.
All right, thank you. We will come back to you at the appropriate time on the agenda to hear your comment. Let's see if there's anyone that is here to speak on item G1, rulemaking proposed property tax rule.
Is there anyone in the audience? No.
I see none.
Not seeing any. Have a motion?
All right, thank you. Members, I'd like to entertain a motion on this.
Can I just add that one
Yes.
quick
Oh,
question?
yes, I'm sorry, yes.
Mr. Moon, first of all, thank you. And I just have one quick question regarding example 16. Why doesn't the child who files the homeowner's exemption late after 1 year of the transfer get prospective relief starting on the year she filed? This example says that she's not eligible for the exclusion at all, but then it says that the assessor may allow the exclusion if the resident hasn't been transferred to someone else. Can you explain how the assessor would make that decision?
So unfortunately, I don't have all the examples memorized. I'd have to take a look at that specific one. But generally speaking, the homeowner's exemption does need to be filed within a year. If the homeowner files the homeowner's exemption after 1 year, they are still eligible for relief. It will just be prospective. So in the case where somebody files a homeowner's exemption late, it's not that they're closed off from the entire exclusion. And if you could remind me, I think there was a second question as well there.
Yes, then but then, like I said, at the back end, it says that it's kind of left up to the assessor may allow for that exclusion to take place. And I'm just trying, I guess was just looking for an explanation. And I think you kind of touched on it, but, so it sounds at the end of the day, the assessor has that flexibility?
Yeah, well, I would say they have the flexibility to, if there's a person who, for example, if there are 2 eligible transferees that get the parent's property, and then 1 eligible transferee lives in the property, moves out, and the second one moves in, the assessor would have some flexibility there to determine that actually the second eligible transferee moved in and it became their principal residence. In terms of whether they could deny the exclusion in its entirety if the homeowner's exemption is filed late, I don't think they have flexibility there. I would say that the assessor would need to process that, but on a prospective basis.
Okay, thank you.
All right, so colleagues,
I'll move it if you need to move the item.
All right, well, I'll make a
Oh, sorry, go
motion.
ahead.
I'll motion a vote to authorize the publication of the notice of proposed regulatory action for proposed amendments to property tax rule 462.520, exclusion from change in ownership, intergenerational transfer.
Second.
Thank you for that. Is there, okay, let's do a roll call vote.
Chair Cohen,
Aye.
Vice Chair Schaefer,
Aye.
Member Gaines, Member Vasquez,
Aye.
Deputy Controller Applewhite.
Aye.
Great, thank you. The motion passes unanimously. Please call the next item.
The next item on the agenda is G2, rulemaking, proposed property tax rule 462.540. Staff request for authorization to publish amendments to property tax rule 462.540, change in ownership, base year value transfers, and to certify amendments previously made via the emergency process, making them permanent. This matter will be presented by Mr. Moon.
Mr. Moon.
Good afternoon again, Chair Cohen, members of the board. This is the second of two property tax rules related to Proposition 19. This one is Rule 462.540, dealing with the base year value transfers. And these amendments were also put out for comment, and any accepted amendments are reflected in the version of the rule in front of you. Staff requests that the board approve the publication of the notice of proposed action for the certificate of compliance and regular rulemaking process for Rule 462.540. And should the board approve staff's request, we would plan to hold a public hearing at the November board meeting, at which time the board would have the opportunity to hear comment and vote to adopt or not adopt the rule, or to make any changes the board felt necessary. Thank you, and I'd be happy to take any questions.
All right, thank you. Colleagues, do we have any other questions for Mr. Moon? None? None? All right, Mr. Moon, looks like we don't have any. We're going to go to public comment.
AT&T moderator, can you please let us know if anyone is on the line who'd like to make a public comment for item G2, rulemaking, proposed property tax rule 462.540?
Thank you. If you wish to make a comment, please press 1, then 0 at this time. I have no comments in queue.
Thank you.
All right, thank you very much. I'll make a motion that we take a vote to authorize the publication of a notice of proposed regulatory action for proposed amendments to property tax rule 462.540, change in ownership, base year value transfers. Is there a second?
Second.
All right, second by Mr. Vasquez. Mr. Applewhite, do you have something to say?
No.
Okay, all right. Second made by Mr. Vasquez. Please call the roll.
Chair Cohen,
Sure, yes.
Vice Chair Schaefer,
Yes.
Member Gaines, Member Vasquez,
Aye.
Deputy Controller Applewhite.
Aye.
Great. Please call the next item.
The next item is...
Thank you.
Thank you.
Thank you, Mr. Moon. The next item is K1A, Executive Director's Report, Organizational Update, Report on the Status of Pending and Upcoming Organizational Priorities. This matter will be presented by Ms. Stowers.
Thank you.
Good
Afternoon.
morning, afternoon, evening. Good afternoon, members. Good afternoon, Chair Cohen, Vice Chair Schaefer, and members. I am Yvette Stowers, Executive Director Report. Members, today we had a very successful Taxpayer Rights Bill of Rights hearing. I do believe that the extensive hearing fulfilled the statute requirements of allowing taxpayers and stakeholders to provide input and address the board on any suggestions, comments, or concerns on California property tax system and the alcoholic beverage tax. With that, I would like to first start with making an announcement on the agenda items for the K other administrative matters. I will be providing my report at a very high level. I will also provide the Operation Priorities Report at a very high level. The Taxpayers' Right Advocate Office Report, which is currently attached to the public agenda notice, allowing the public to review it if they like. That report will be postponed and delivered at the September meeting. The Property Tax Deputies Director's Report, which is also attached to the public agenda notice, will be postponed, but the public may review it if they like, and we will report out again at the September meeting. The ledge report will continue as planned. So those are our adjustments. And I will start with thanking Ms. Thompson and her team for an excellent report, thanking Peter Kim for all the marketing efforts that he did, and thanking Board Proceedings for arranging and managing that very important and informative meeting. Now, members, for my report, I have 3 items that I will provide an update on. The ability to hold virtual meetings under SB 189, a recap of the Northern California Assessors Association Regional Conference, and highlight several upcoming meetings of note. Okay, SB 109 is a budget trailer bill that was signed by the governor and filed with Secretary of State on June 30th, 2022, and is operative for July 1st, 2022. Section 20 and 80 of the budget trailer bill make changes to the Government Code Section 11133 to allow for teleconference board meetings similar to what we had did in the past while we were under COVID. The bill reestablished many of the provisions of the previous executive order that suspended some of the provisions of the Bagley-King Open Meeting Act by allowing public bodies to conduct meetings via teleconference. The changes to the government code was sunset on July 1st, 2023, so the changes apply to all meetings held before June 30th, 2023. Members, as we continue with our scheduled meetings for the remaining of 2022, for the remaining of the 22 year, I recommend that the current board vote on whether we hold our meetings in person or by teleconference. A decision to have meetings by teleconference, I recommend consider the potential effects it would have on appeal hearings from the various state assessees during the month of October, November, and December. Just reflecting on some of our previous conversations with representatives and how they prefer to have in-person hearings as opposed to remote. Finally, to conduct the meetings via teleconference, I would like to bring out that there will be a small savings estimated at $1,600 to $2,000, and that savings will come from not having to contract with CHP for security. For the next item, members, as you know, we had our Northern California Assessors Association Regional Conference this past August 2nd through the 4th. I just want to take the opportunity to thank the association for inviting us to the meeting. Several of the members and their staff was there, I was there, and so was BOE staff. Also would like to acknowledge that they had great speakers, but one speaker that was really fabulous was our very own Glenna Schultz, principal property appraiser with the Property Tax Department. Ms. Schultz provided an in-depth training for the assessors staff on the topic of the day, Prop 19. I want to recognize Ms. Schultz for the training she provided, as I have received a lot of positive feedback from those who attended. Thank you, Ms. Schultz. Moving on, I'm going to highlight a couple of important dates. September 29th, 2022. The BOE has been invited to participate in the California Society of Enrolled Agents Annual State Tax Agency Liaison Meeting. This event will be held virtually. I will attend and give a brief overview of the BOE, along with staff from the Property Tax Department who have been asked to present on Prop 19. This will be our first appearance at this annual event, and I believe it is an excellent opportunity and forum for outreach to our stakeholders on not only the agency's role in property tax, but also for getting information to our stakeholders on important property tax information. Next, on October 19th, we will hold our annual meeting with assessors as part of our October 18th and October 19th board meeting. And finally, On November 14th, the 120th Annual California Assessors Association Conference will be held in Solano County. I will continue to keep your offices up to date on the details for these upcoming events. Members, this concludes my presentation, and I'm available for any questions.
Awesome. Thank you. Let me see on my left. Colleagues, anyone, any? Yes, Mr. Gaines.
I just want to comment
Yeah.
on the California Assessors Association meeting that was held up at Tahoe. I thought it was, I attended the first part of it, the breakfast, and a couple of the speakers, and just thought it was very informative. A lot of interesting discussion topics on housing, and also having to do with fire prevention, things of that sort. So it was nice to see our team up there, and I didn't get a chance to hear Ms. Schultz speak, but it was just, I thought, good to be there. I enjoyed being there and touching base with a lot of my county assessors. So, thank you.
Yes. Anyone on this side? No? Mr. Eppolite? No. Okay. Thank you. I don't think we have any questions for you, Ms. Stowers.
Thank you.
Great report. Let's keep moving, folks. Let's go to public.
Yep.
Okay.
The next item is K1B, Executive Director's Report, new board meeting minutes, guidelines, and adoption of board meeting minutes for May 24th, 2022, June 28th, 2022, and July 26th, 27th, 2022. This matter will be presented by Ms. Stowers.
Thank you. Members, at last month's board meeting, I reported that as part of our strategic plan, we were working on modernizing and standardizing many of our policies and process, and the staff was reviewing our board minute policy. We have conducted the review and received feedback from everyone, all of the members, or your office staff. After the review and considering the feedback, we have concluded that the best look for our minutes so that it's most transparent and efficient is to have it go back to where they were April 2022. So basically, we will continue to document the date, start, and end time of each meeting, record the members who were at the meeting, document the specific actions taken by the board during the meeting, basically the motions, descriptions, so forth. Document the topics, presenters, and staff reporting at each meeting, and most importantly, because I heard all of you, provide hyperlinks to the materials presented and discussed at the meeting. Those will be on our minutes so that when you're reviewing the minutes or going back to them 6 months later, you can click on the link and read whatever that document is. Members, the May, June, and July board minutes have been drafted in accordance to that. They're on the pen, public agenda notice. A copy is at your desk, and I believe your staff also received it.
All right. Thank you.
I have
We have a question for you, Ms. Stowers.
Yes.
Go ahead, sir. Go ahead, sir.
Thank you, Madam Chair. I would like to say thank you to all of those who looked into the issue of how best to record the BOE minutes. I think it's a good idea that we continue to handle our board meeting minutes the same as we have handled them for the last several years. Our tried and true method of reporting components with Robert's Rules of Order maintains our professionalism, standardizes what the taxpayer community has come to expect from us. I've chaired countless meetings over the years, and I can say from experience that keeping straightforward minutes benefits all of us and everyone. I believe the proposal before us accomplishes this, and I thank all my colleagues for supporting it.
Thank you.
Okay. Is there any public comment on this?
Let's see. AT&T moderator, please let us know if there is anyone on the line who would like to make a public comment regarding the board meeting minutes.
Thank you. If you wish to make a comment, please press 1, then 0 at this time. I currently have no comments in queue.
Thank you.
right, great.
Motion?
Yes. Well, no, there's no action. Yeah, no
the
action
minutes.
needed on this one.
We have to approve the minutes, we have to adopt the minutes.
Yes.
If there's a, well, if there's a recommendation from the staff to approve the minutes, I don't know about the rest of you, but I'm not prepared to approve the minutes because I know there's been some revisions, and I'm just looking at them, and my staff, I know, just got these yesterday, so, in looking at them quickly, there's some changes I'd like to make, but I'm not prepared to do them today, so if we could put this off, I'd appreciate it. Otherwise, I don't think I can vote on them or approve them.
Okay. No problem. You have 30 days, or at least to the next meeting scheduled.
meeting, please.
Yes,
Thank you.
actually, technically, the next meeting would be tomorrow.
Oh,
Now, will you be ready to vote on it tomorrow?
why don't we do it in September, the 1st?
All right, we'll do it at the end of September. No problem. Thank you.
Thanks.
Excuse me. Okay, operational priorities. Pleased to report, since last month, we have filled 2 positions. One vacancy was a promotion of an internal candidate, and the other one was a new to state service. Our remaining vacancies are in active recruitment, and we continue to make meaningful progress in our goal to reduce vacancy using efficient and timely merit hiring practices.
Is that it?
That's it.
Okay.
Okay.
Congratulations.
Now,
That's
one more
great.
thing, Prop 19 update, we're in the green on far as implementation.
You
That
said
is
we're in the green?
green, meaning that it's all go, it's all good.
Okay.
We use green, yellow, red. Green,
It's
great.
like red light, green light, yellow light, right?
Yellow, caution, red, warning, warning, we have a problem here.
So the smooth sailing, what does that mean? Like, what does that actually look like?
As far as our implementation of it,
Okay.
starting with SB 589,
Okay.
all of the property tax rules that we've done, all of the forms that we had to design and have you guys approve.
Okay.
That was what we're calling in the green.
Green light. Okay, great. Thank you for the clarification. I see no other question. Oh, we do have a question from,
I don't know if Ms. Renati's going to bring it up, but I remember during our pre-meeting that I think we're down to 16% vacancy.
Yeah, I held off on that because I knew
Okay.
you was going to ask.
All right.
As a result, because she's not going to report, I'm standing in for Ms.
Oh, you
Renati
are?
today.
Okay.
As a result of the agency currency, as a result of all our great work, our current vacancy rate is 16%.
That's great. Yeah, wonderful. Thank you for that effort. And I think it was 85% active recruitment.
Yes,
That's very encouraging.
yes.
Yeah, thank you.
Okay.
awesome.
That concludes the executive director's report, including Ms. Renati.
Thank you. Thank you. All right, let's keep it moving. Let's take
The
public,
the next
I think we
item?
take public comment on this report? No?
No.
No?
The next item on the agenda is K5A, Legislative Research and Statistics Division's Chief Report, Legislative Issues, Update on Administrative and Program-Related Legislative Bills Impacting the BOE. This item will be presented by Mr. Weatherby.
Mr. Weatherby, welcome. Good to see you.
Good to see you too, honorable members of the board. So good afternoon, Chair Cohen, Vice Chair Schaefer, honorable members of the board. This is Dustin Weatherby, Chief of the Legislative Research and Statistics Division. So attached to the PAN is a summary of the legislation affecting the Board of Equalization that is still pending in the legislature. The last day for the legislature to pass any bills is tomorrow, August 31st, upon which the legislature will adjourn for the 2021-2022 legislative session. Any bills the legislature passes by September 1st that is in the governor's possession, the governor will have until September 30th to either sign, veto, or there is an option to not take any action upon which that bill will become a law. So moving on to the PAN, as I mentioned earlier by Executive Director Stowers, as part of the 2022-23 budget, SB 189 signed by the governor included a provision to amend Government Code Section 11133 to allow state agencies the flexibility to meet remotely via teleconferencing, similar to the governor's signed executive order during COVID until July 1st, 2023. So for legislation that's still pending in this session, the first bill I want to highlight is BOE-sponsored SB 440 by Senator Dodd. SB 440 authorizes the BOE to provide deadline extensions, and penalty and interest relief to taxpayers under the alcoholic beverage tax law during a governor-proclaimed state of emergency. SB 440 mirrors similar changes made by CDTFA to other special tax and fee programs, ensuring equity and administrative efficiency in providing taxpayer assistance during such emergency circumstances. The bill was amended August 15th to specify that deadline extensions and relief is limited to the lesser of 12 months following the issuance of the state of emergency or the duration of the emergency. The bill passed the Assembly unanimously 77-0, and the Senate Governance and Finance Committee unanimously yesterday, and additionally passed the Senate 36-0 this morning. So the bill will now head to the governor's desk for consideration. The next bill is Senate Bill 1494, authored by the Senate Governance and Finance Committee, which contains one of the board-sponsored legislative proposals to amend Revenue and Taxation Code Section 97.68 relating to a sales tax augmentation fund to correct a reference from State Board of Equalization to the California Department of Tax and Fee Administration. So this bill is currently on the Senate floor, and it's on a special consent calendar, so it's very likely it's going to go to the governor by tomorrow. So the next bill is Senate Bill 1496, also authored by the Senate Governance and Finance Committee. This contains another one of the board-sponsored legislative proposals to amend Revenue and Taxation Code Section 32471.5 to extend the sunset date for offer and compromise program for open and active businesses under the alcoholic beverage tax law an additional 5 years until January 1st, 2028. So this bill is currently pending on the Assembly floor. The next bill is Assembly Bill 1206 by Assemblymember Bennett, which will require that a rental unit continue to be treated as occupied by a lower-income household when the income of those tenants increases up to 140% of the area's median income. If the owner is a community land trust whose land is leased to low-income households for the fiscal years 2022-23 through 2027-28. The board voted at the February board meeting to support AB 1206. The bill passed the legislature and is now heading to the governor's desk for consideration. Senate Bill 989 by Senator Hertzberg will allow certain taxpayers to defer payment of local property taxes with penalty and interest relief if they have claimed a Proposition 19 property tax relief with the county assessor and have requested deferment with the assessor within 1 calendar year, but before January 1st, 2024, of receiving the first tax bill for the property. The bill's provisions only apply to counties with a population of 4 million or greater as determined by the 2020 federal census. So currently this would only apply to Los Angeles County, but counties with less than 4 million residents would need a resolution of the Board of Supervisors after consultation with various local officials if they would want to choose to participate in the bill's provisions. So that bill is currently pending on the Assembly floor. In the final bill, members, is Senate Bill 518 by Senator Laird, which will require the BOE, upon request, to provide confidential taxpayer information on the wine grower tax return and schedule for returns filed on or after January 1st, 2023, unless the taxpayer is a natural person. The bill's provisions require returns to include an opt-out box for taxpayers who do not wish to have their confidential taxpayer information shared publicly. The bill passed the legislature and is now pending on the governor's desk. So this will conclude my presentation on this item, and I'm available to take any questions you may have. Thank you.
Thank you very much, Mr. Weathersby. Let me see if my colleagues have any questions. Yes, Mr. Vasquez.
First of all, thank you for this report. I think it was real good, especially you're giving me what's hot off the press as of this morning. But I have a concern about a couple bills. One of them is AB 1206. Bennett, I guess is the author of it, that extends the welfare exemption so that property owned by a community land trust that is used exclusively for low-income rental housing will continue to get the exemption, even when the income of the occupants increases up to 140% of area median income. The bill requires the legislative analysts and the BOE to annually report on the effectiveness of this exemption. Do we have forms or ways to get the data on these properties? For example, their location, the amount of rent, and the tenant's income, and will the information be kept confidential?
So thank you for that question, Board Member Vasquez. So there is an avenue that the BOE uses to request information. The County Assessed Properties Division will do an annual request of county assessor offices of data that is required to be reported for the exemption. This particular requirement is under Section 41 of the Revenue and Taxation Code, which essentially states that any new tax expenditure needs to have some sort of data that is reported to show the efficacy of that tax expenditure. The current written portion of Section 41 only applies to the corporate income tax, the sales and use tax, and the personal income tax, and it does not apply to property tax. So without a clear statutory requirement, county assessors are not statutorily required to report any data to the BOE. Although some counties and CAO requests do provide the data, we do not get all 58 counties in participation. As far as what data is going to be requested, I haven't looked at the bill in a while, so I would have to go back and see exactly what the bill's language requests of the BOE and of the county assessors. But I believe in the legislative analysis for AB 1206, we do raise a concern about those kind of data requests of county assessors when there's not that statutory requirement.
I appreciate it. My second one is in regards to AB 1933, which was Freeman's bill, which adds new RTC section 214.15.1 to provide the welfare exemption for property owned and under construction by a qualified nonprofit that builds and rehabilitates single or multifamily residential units that will be owner occupied and sold only to first-time low-income homebuyers if the property is subject to a 45-year recorded agreement with the local government. This new section will remain in effect only until January 1st of 2034. The bill's sponsors provided us with the data on 11 housing development projects, all in Los Angeles County, built dating back to 2005. You analyzed 3 of these and found that they were all strictly low income and that they were under construction for 5 to 6 years. Under this bill, 100% of them would qualify for the exemption, but only during the construction. Is that correct on those?
Yes, so essentially, under the construction, they would receive the welfare exemption for the property tax. And then once the units are rehabilitated, completed, and, ultimately sold to the tenant, then that property will be reassessed to what its purchase value was. So if a entity received the property tax exemption for 5 years, all the units are completed in 5 years, and they complete the sale of those units, then the property tax would then go on to the individual home buyers in that instance.
Upon the sale?
Upon the sale of the units.
Thank you.
All right. Anyone else? I think that's it, Mr. Weathersby. Thank you for your presentation.
Just have to call the AT&T moderator.
Yes.
AT&T moderator, please let us know if there's anyone on the line who would like to make a public comment regarding the Legislative Research and Statistics Division report.
Thank you. If you wish to make a comment, please press 1, then 0 at this time. I have no comments in queue.
Thank you.
I had a question.
Okay, Mr. Schaefer has a question, Mr. Weathersby.
Yes, Dustin, what is involved in BOE sponsoring legislation? What do we actually do to earn that honor? And you know that. I don't.
So every fall, the agency staff will identify maybe some technical or administrative changes to current law to consider, and then we would bring those proposals with an analysis forward to the board to either support and move forward as a legislative proposal to the legislature, or the board could reject that proposal and not move forward. So traditionally, the board usually follows a lot of the technical and administrative nature type proposals, and those usually go into committee bills. As far as any other items, I would like to defer to legal counsel's opinion on any of those other items until their opinion comes through.
Fair enough. Okay, thank you.
Thank you. The next item is L2A, Board Member Requested Matters, Board Member Initiatives, Agency-Wide Branding and Communication Campaign Update. Discussion, follow-up, and discussion of ideas to create effective branding and communication strategies for the State Board of Equalization as it pertains to Goal 4, Agency-Wide Branding Campaign of the Board Member Strategic Plan, presented by Mr. Gaines and Vice Chair Schaefer.
Mr. Gaines, Mr. Schaefer, anything you want to share with us? Mr. Gaines?
Yeah, I'm looking for my staff. I thought
They went
were
home,
going to give
Mr.
us an
Gaines.
update.
They went home. Oh, here they come, here they come.
Right.
We're in the conference room, sorry.
Okay, no problem. Just come on up. We're eager to hear your presentation.
Okay. Chair Cohen, honorable members, we just wanted to update you, as we said we would last month, on the branding and communications work group that Senator Gaines and Vice Chair Schaefer chair, and we work with them as their staff to help them. So our target audiences, and we did get input from some of the board members through the executive director, so we don't know who gave the information, but we did get your input. So our target audiences are homeowners, seniors, veterans, disabled, natural disaster victims, nonprofits, California taxpayers, elected officials, state, local, and federal, business associations, and farms. Bless you. Some of the things we're looking at to increase our bandwidth in letting the public know what we do and engaging with us are to produce various videos to be posted on social media and the BOE homepage, and produce a video featuring board members explaining about what their BOE, what the BOE does, and what we do, what you do as members of the BOE. Also place taxpayer Bill of Rights hearings, promotional videos on the BOE homepage, along with others that carousel across the front, which we have learned it doesn't meet ADA requirements, so we would do it to meet ADA requirements. Produce monthly board meetings preface videos after the PAN is released to appear on the homepage, and have board member welcome videos that would be on the board members' pages. And then I'm going to turn over to Matt Cox from Senator Gaines, Chief.
Thank you, Gary. Sorry that we were late, everyone. Some other ideas that we have discussed are direct mail, where we'd be creating and distributing pieces on various BOE topics as appropriate and timely. Some ideas would be to new home buyers, explaining to them property taxes and the Board of Equalization's role. Nonprofits, explaining the property tax exemption. Senior homeowners, explaining Prop 19. And, for example, fire victims would be another target audience as well, explaining the help that's available to them after a tragedy. Gary, I'll keep going a little bit. We also discussed conducting some more board member events, in-district events individually, but these could, of course, include as many as 2 board members at a time. Some of those ideas were conferences where the members can appear as speakers discussing any tax-related issue, but specifically BOE issues, hopefully. We could also coordinate with assessors, legislators, and others on seminars to include BOE member participation, or partnering with organizations to host informational workshops. And this is something that in our time in the legislature that I thought that we did to great effect, where we would piggyback with and join with pre-existing groups like the enrolled agents, for example, who have expertise and who are willing and in fact mandated in some instances to provide educational opportunities. And so there's a wide group of organizations, veterans organizations, for example, retirement communities, any community of interest that's affected by property and property taxes, which of course, pretty much runs the gamut. So those are some of the ideas. I'll do one more and then you want to summarize.
Okay.
Right, we also discussed, and of course, it's be subject to the board members' desires and agency budget, placing social media informational ads, which is something we could do board-wide and also in our individual districts, and local radio and television ads as appropriate as well. Go ahead, Gary.
Okay, sure. The other things that we are exploring are the Senator Gaines and Vice Chair Schaefer and our teams are adding about the BOE information to all BOE employment outreach messages, just to help people understand more about what we do in our targeted roles. Also, helpful links posted on the board members' websites, and also board member newsletters, which Senator Gaines does, extremely well. Then partnerships with local assessors throughout our districts through electronic communications and newsletters, where we would work with them to get our information out through their network as well to the constituents. And then the last thing would be about the BOE board member publications available at local assessor offices. So if somebody sees that on the counter or can find a link on their website. So those are kind of the things that we are considering. There's a lot of ideas there, and we still welcome input from the board on your ideas, and then we'll proceed forward. The members will.
Just in terms of what I am interested in and would like to pursue would be opportunities for kind of town forums or whatever you want to call them, where I could come up and we might even bring someone from the BOE, work with a local county assessor, and kind of use a team approach to addressing issues. But I think there's, Prop 19 is kind of the big issue right now, but we could really address any question that they would have as it relates to assessment of property. And in terms of the video, I think video idea is a good one, and that ought to be incorporated in our regular website. And in terms of outreach, I really like the social media concept, because I think the clear issue is over and over again, what do you do at the BOE? And so I think if we can communicate that in a clear, simple, concise way, and that's kind of the trick. But, I define it as, in some ways, as, it's called a tax board by some folks, right? Because we're determining, well, we have certain tax duties, but the assessors and our duties are to value property, which then determines taxation. So I just think those are a variety of options that certainly I'd be interested in my district. We are doing the electronic newsletter and have found that to be effective. We get a lot of comments from constituents that like to know what happened at our last board meeting, what is the latest update on any particular issue, but again, usually Prop 19 at this stage. And so I think I'm hoping that those are helpful, and those are things that each of you could look at and determine what makes sense in your own district.
So you're suggesting, I just want to summarize what you just said. You're suggesting newsletters, and what was the other one?
Videos, and then social
Videos.
media.
These videos, do you email them to your constituents, or do you just post it on the website?
Well,
I like that idea.
yeah, we'd have to, I post mine. Okay, so we'd have to figure out what is the right path,
Right.
Depending on the issue. But I would think we could do it certainly on the BOE website, and then we'd have to look at the right mechanism for, how do you determine the list? You probably want to take a look at your constituency and how do you outreach that constituency within your district.
So are you suggesting this as a strategy for agency-wide branding?
Well, I would see that as a means of communication. I think the branding aspect is, you need to know what we do at the BOE so we can be helpful to you. So I think we just need to get the word out of what a member of the BOE does and how we can communicate and help you. We often get calls, and I'm sure it's true with all of us, but we get a lot of calls from folks that just don't understand where to go for government.
Mm-hmm.
And so, and I think we should always, and I'm sure we are, I know I am, you can call me about any issue, and we're going to figure out who you need to talk to, because government's complicated. And so, in my view, it doesn't matter if it's local, state, or federal. If you have a question, you're looking for someone to act as that conduit, and I think that we can be effective at doing that for our constituents.
Thank you.
They love having, the ability to get on the phone or even send us an email and get an answer. We really try to do it quickly, because often that's not the case. And I wish everybody could respond as quickly as we do. And if we're not careful, maybe we'll get inundated with thousands of calls, and then we'll have problems returning and responding quickly enough. But that hasn't been the case. But I think we certainly can do more in terms of our outreach to let people know that we're available and we want to get you down the right path. Certainly within our own realm at BOE, but some people will say, well, what can I do about Prop 19? Well, I say, well, you need to talk to your legislator. Well, who's my legislator?
Mhm.
Then we'll get them in touch with that office.
All right. Thank you very much. So let's see if do you have any questions? Yes, Mr. Vasquez.
First of all, thank you, Member Gaines and Vice Chair Schaefer, for working on this. And I thank you for your ideas, and I think this represents a positive step forward for me, because the overall purpose is to ensure that the BOE's function and service is clearly understood by the public without confusion and builds public trust. To me, our brand should be our key message that incorporates three things. The first, I think it should, communicates the core values, beliefs, and goals of our organization, thus establishing trust. Trust is earned by doing what we say and not having the public trying to second guess whether the messages they receive from us are clear and reliable. I know that branding is a largely visual, so this is a challenge, but visuals are easy for people to remember and identify with. The second one, I would think, is once we have a distinct brand with our mission and purpose, we should consistently use it in our messaging to build stronger relationships with our community. I think we saw this happen with Prop 19, like you mentioned, to an extent without a brand. As launch implementation as a new program, residents statewide began to identify BOE as the agency that would provide answers to questions and concerns regarding it. Using our brand for every new program or agency initiative will build consistency and reliability. And I guess the third one would be, part of our branding efforts should also include collaboration with other agencies, industry, small businesses, nonprofits, and community groups to raise awareness about the ways people can utilize our services, access the correct information they need, and protect themselves from wrong answers that they may otherwise cross their path. Again, I'm very supportive of our efforts, and I wanted to add these three concepts as ideas that might be incorporated if you don't already have them in your plan moving forward.
Great, thank you very much. That spurred a couple of ideas in my mind too. We stay in constant contact with our constituent services person on our team, and you get a variety of different questions. Sometimes they're CDTFA related, right? They just need to know that we don't have that duty any longer, that particular duty. But we'll get a lot of calls from people that are having issues with nonprofit status, and they're just trying to get their paperwork figured out. And we've been given updates here at the BOE and how that's being streamlined, which is very encouraging. But, you know, that could be you could do a town hall on nonprofits and we could have our expert from the BOE speak about what is the process and how do we help you along through that process, and give them contact email or phone number on who the right who the right person is to speak to. And more recently, I've had issues with boats. I don't know if you're getting calls about boat valuation, but I've received.
Me in the city, no.
Yeah.
I can't. We don't.
Oh, you don't?
We don't have that problem.
I was thinking the Bay, San Francisco.
Pier
But-
39, what do you mean?
Yeah, no, I think the slips are too expensive.
And I had another person give me a call about closing a business,
Mm.
and that was CDTFA related, but we were able to put them in touch with the right person and it got it resolved. So I just think we need to amplify it so that people know what we can do and how we can connect people. Because the people we're helping, it seems like 9 out of 10 cases, we're able to at least put them in touch with the right people, if not resolve the issue.
All right, thank you very much. Does that conclude your presentation?
It does, thank you.
Do you
We
have any
will
action items or takeaways?
We will continue to work, to come up with a specific plan to put before you, but these are just ideas that we're considering. We'll certainly get your comments and incorporate them, Member Vasquez.
Okay,
Appreciate it.
thank you. Did you want to say something? See your finger on the mic?
Yes.
Go ahead.
Hang on.
I had a question for Mr. Nanjo, actually.
Oh,
Okay, Mr. Nanjo, we have a question for you. Thanks, gentlemen.
Mr. Nanjo, they had mentioned something about direct mail. Did you, in their presentation?
Yes, I heard that.
Did you have any concerns about the use of direct mail?
Thank you, Deputy Controller Epplite. The concern would be over the mass mailing regulations. We would assist the board members in making sure that they're not running afoul of that. So we'll work very closely with the work group along those lines.
Okay.
Thank you.
All right. And the other thing I would want to add is that going forward for board members, that you would want to make sure to leverage existing documents that staff has already created as much as possible, and that board members not try and create original documents. There's been so many documents that have already been created by staff on the website itself that there's no need for staff to try, or members try to create their own documents.
Sure. Absolutely. No, I think it makes sense. It was interesting listening to Leslie Morgan on some of the signature issues, right?
Right.
It's like, hey, if we had one form that everybody was following, it would make it a lot simpler. But yeah, I think the same applies to ourselves.
And the other thing I would want to note is my member probably does a couple of webinars a week. And, I would also encourage the members to partner with local organizations. You remember partnering with assessor offices, but also, county bar associations. Think of this, tax groups. But just within local bar associations, you have real property, estate planning section. There's 2 or 3 groups within a local bar association with Prop 19 to get
Sure.
get the word out.
Yes.
And I really think we have local tax groups within each county that that's an opportunity.
That's right. You could put a panel together and include,
Well, the taxation group, that's the third section.
yeah, you could have an expert
So that's
tax attorney that could also provide information.
right, but that's
to
3
others.
groups within probably each local bar, county bar available to you
Sure.
to get the word out now.
Absolutely. That's a good suggestion. Thank you.
Thank you. All right. Let's take public comment.
AT&T operator Do we have is there anyone on the line who would like to make a public comment regarding the item L2A, board member requested matters?
Thank you. If you wish to make a comment, please press 1, then 0 at this time. I have no comments in queue.
Thank you.
Thank you.
All right, let's call the next item.
The next item is M1, public policy hearings, Proposition 19 implementation. There are no planned staff reports or external speakers for this agenda item for this month's meeting. However, persons who wish to address the board on this topic as a public comment may do so. I have one written public comment that I've received on this item.
All right, please read it.
I'm going to read it into the record before I go to the AT&T moderator. The public comment is being issued by Marie Blase. Public was totally misled by the title Proposition 19, the Home Protection for Seniors, Severely Disabled Families, and Victims of Wildfire or Natural Disasters Act. Hidden within the sneaky ballot measure was the provision to prevent parents from leaving their family home to children without their home's value being reassessed, making the subsequent property tax unaffordable for inheriting children. Please repeal this portion of Prop 19 so that parents can leave their family homes to their children who wish to raise their families there without the burden of unaffordable taxes forcing them to sell. I'm going to go to the moderator at this point. AT&T moderator, please let me know if there's anyone on the line who would like to make a public comment regarding this matter.
Thank you. If you wish to make a comment, please press 1, then 0 at this time. I do have one comment in queue. It'll just be one moment.
Thank you.
And our comment comes from the line of Natalie Vanderberg. Please go ahead.
Hi, just wanted to say thank you for an opportunity for me to just clarify something. And I did submit a comment via email, but I'm not sure if it got read or if I missed it. But we've had a lot of talk about Prop 19 and grandchildren and passing down real estate and so on and so forth. One thing that I haven't heard, and I apologize in advance if this is not the correct form, is specifically for parents who have a permanently and severely disabled child. I have a 4-year-old who's permanently and severely disabled, and I was wondering if I had seen a couple of bills that had proposed some change in just the language and just looking at a new approach to have it say that, homeowners who are the parents or legal guardians of severely disabled children can also claim this exemption. And I was wondering if there was any headway on that and if there's any true guidance to how someone can navigate that. We have sold our home and we have bought a new home. This was after the proposition was passed. We were under the assumption that because we had a severely disabled child that we were able to provide the doctor's attestations, which we did, and that we would be able to apply for this exemption. But there's been some confusion, I guess, about the fact that the child is not a homeowner. He's only 4 years old. So could there possibly be an extension of the claimant being the homeowner who is the parent or legal guardian of this severely disabled child? Obviously, it's very stressful to navigate and to raise a child who's severely and permanently disabled. And we have also submitted permits to do construction on the new home, hoping that we could have this exemption definition clarified.
Okay, Carla, just can you summarize what exactly are you asking? You want clarification on what? One more time, caller?
Sure. Sure. I guess we submitted our exemption form because we are the parents of a severely disabled and permanently disabled child. That child is not an owner because the child is only 4 years old. And so what I'm asking for is does the proposition extend to homeowners who are the parents or legal guardians of severely disabled children that reside in the home?
Okay, hold on a minute.
We're having some.
Give me a second.
Yeah.
I think we're
Sure.
working on getting an answer
Sure.
for you. Mr.
Oh,
Nando,
okay, sure,
do you have at the very least, a reference, a telephone number, and email that we can give this caller?
What I would recommend, just briefly chatted with TRA and property tax. Mr. Young, and I don't want to misspeak for him, but he indicated that he's not aware of anything that would help this particular taxpayer situation. I was checking with TRA to see if Ms. Thompson had gotten any kind of comments from her. It doesn't appear to be so. What I would recommend is if this caller wants to contact our TRA office, she can get more information from our TRA, and we can, at the end of the day, there may not be anything we can do, but at least we can kind of point her in the right direction.
Okay, Ms. Thompson, can you come to the mic and just tell the taxpayer your contact information, just so that, caller, we're trying to get you on the pathway to getting your question answered. We don't have all the facts in your particular situation, so TRA is the Taxpayer Rights Advocate. Taxpayer Rights Advocate. It's on the Board of Equalization website. And the number for you to call is...
I'm going to actually, I'm going to actually have her contact Miss Margie Wing of my staff from the TRA office, and her direct line is 916-274-3368. And we'll be happy to look into that for you.
Thank you very much.
And do you mind repeating your name?
Sure. It's Natalie Vandenberg.
Okay. Thank you so much.
Okay. Are there any other callers?
Want to find out? AT&T moderator, are there any other callers on the line for this matter?
I have no further comments, thank you.
Thank you. We'll move to the next item.
Please.
M2A, Public Policy Hearings, Impact of Public Calamities on Property Tax Administration, County Boards of Equalization, Assessment Appeals Board, AAB, Remote Hearings. There are no planned staff reports or external speakers for this agenda item for this month's meeting. However, persons who wish to address the board on this topic as a public comment may do so. Let me call the AT&T moderator. AT&T moderator, is there anyone on the line who would like to make a public comment regarding this matter?
Thank you. If you wish to make a comment, please press 1, then 0 at this time. I have no comments in queue.
Thank you. The next item on the agenda is N, public comment on matters not on the agenda. Persons who wish to address the Board of Equalization regarding items not on the agenda may do so under this item on the agenda. Please note that the board cannot take action on items not on the agenda. However, the board can schedule issues raised by the public for consideration at future meetings. We do have someone in the audience who's filled out an appearance sheet to come make a comment. Paul C. Ballard, please come forward.
Please,
Right,
to the
yeah.
mic.
That's fine. Right here. Sit in
Anyone.
the seat.
Good afternoon, Chair Ms. Cohen and Mr. Schaefer, Vice Chair. We've spoken and had a Zoom meeting earlier, about 2 years ago, right as the pandemic hit, regarding this topic, and I had addressed your your board via a phone conversation a couple of years ago. And this is regarding the situation in the County of Orange, which then I've also then worked with Gary and Sue Blake, which apparently is not just limited to the County of Orange, but it certainly has affected myself and my family. And it has to do with non-deed held properties, such as stock with the senior communities. And this is what Mr. Schaefer was familiar with when you're holding shareholder stock. The current situation right now is just a week or so ago, the taxpayer advocate of the County of Orange Assessor's Office has suggested for the best way for me to solve this is simply to sue the County of Orange. That was not satisfactory to me. They have marked that our property was taken as a foreclosure, and the reality is no such foreclosure has taken place, and I've requested this document. They can't produce it, and Claude Parrish isn't forthcoming. He's contacted me 3 times now and just wants me to write off the fact that our house has been taken, bulldozed, a new house has been built and then sold. We haven't received a dime. And one of the other things that I did during the pandemic here was this is happening to more than just one family. And what I did during the pandemic is rather than continue to fight why this is taking place, I thought I'd look at the government side of how this is taking place through the assessor's office. And everybody claims everybody's doing everything just the way they're supposed to. But the reality is there are tens of thousands of APN numbers, assessor parcel numbers, that are not on the public record. And this is the mechanism that I have determined. I was the president of the Board of Realtors. This is the mechanism that I've determined that is being utilized by a group of less than scrupulous individuals because there's no public record of ownership of these homes, and you pay for them with cash. There are no recorded deeds, so it's held with stock and it's not recorded at the county recorder's office. I didn't want to go away on this. It's a serious issue. It's affecting certainly more than myself, and I want to apologize for my casual attire. I got a message, a text this afternoon from Gary saying that you guys are having a meeting today, and he was going to call me up and have me speak that way. And I said, well, I'm going to jump in the car and come on over, but it's National Beach Day, so excuse my casual attire.
Did you drive all the way up from Orange?
No, I was actually up at the ranch outside of Mariposa County.
Okay.
But I was casual, and I have nicer clothes in the car, but Gary said don't bother. But there really is something needs to be done. If all of this is truly acceptable, it really isn't. With computerization, there's no reason that the APN numbers need to be in a separate set of books. Politely put, apparently at least 2 assessors' offices that I've been in contact with Sue watching, or Sue Blake being aware of this, they have 2 sets of books, the public set of books, and then they have thousands of homes in a separate set of books that are not on the public record. And this is completely unacceptable as far as I'm concerned, and in the real estate industry. And I know it's shocking to say, but it's so. And I can produce it even with my phone if need be. So I've checked the computers, I've checked the title plants, I've checked the assessor's office computers, I've checked the assessor's office hard paper books. And what I get from the County of Orange, George Singletary, the lead gentleman potentially running the assessor's office, is that he refers to these APNs as fictitious, whereas when Mr. Parrish contacted me, he refers to them as factitious. Either way, it's unacceptable because it's the lack of the public safeguards, of the government safeguards to protect the seniors and the heirs of these homes that you pay for with cash is completely unacceptable, and this is something I'm just trying to address because the assessor's office points to your board as we're following all the rules. And apparently we may need some legislation if if laws currently aren't being violated, which I have a hard time believing they're not, but if this is the legitimate way that California is doing business as our 5th largest economy on the planet, I think we need some legislation to help protect the safeguards of the seniors and their heirs that purchase homes with cash and hold them with a stock versus a deed under the Davis-Sterling Act of 1986. And I'd certainly be glad to entertain any questions. I've done too much investigative work.
Our time, this is public comment. You didn't come to testify, but perhaps we can invite you next month.
I appreciate that.
Yeah.
I appreciate that.
So a couple things, I'm thinking, time's up, so, but sounds like we do have Sue Blakeman and Gary Gartner have your contact information, so we can follow up with you directly.
Correct.
Since you are here, you might want to turn around and talk to David Young, David, maybe you can raise your hand, talk to David Young, and you might be able to get some answers and some questions with Mr. Young. He is very knowledgeable about all things property. Mr. Nanjo over there is our general counsel. Also might want to have a word with him before you drive back to Mariposa. Okay?
I appreciate that.
That's the best we can do for you right now because the item is not agendized and it's just public comment at this point, but let's continue the conversation.
I understand. Thank you. We do need to work on this. Thank you for allowing me to address your board, and thank you for being here and taking care of the taxpayers. One last, I did a video, and I'd love to put it up at some point, but I tried to go in and pay the taxes at the tax collector's office, and I did a little video, and that's what I sent to Gary and Sue. They don't have the APN numbers, and so you aren't allowed to pay your property taxes at the tax collector's office.
So where do you pay it?
Well, this is the interesting scenario. You just pay the
I know,
management
Mary, I
company.
know.
You pay
Okay.
the management company pays it, but this is then part of the mechanism of how the houses are being taken, because the individuals aren't allowed to pay their taxes on their own, which I also think is completely incorrect.
Okay.
Thank you.
Thank you.
Thank you for coming.
Thank you, Mr. Chairman.
All right, Mr. Keddy, let's get back on track.
Yes, it's fine. I have, for this item, I have one written comment that I will read into the record, and then we'll try the AT&T moderator. This written comment was submitted by Matthew Rakela. Many taxpayers across the state have experienced restricted access to their property during the pandemic, negatively impacting their property values. California Revenue and Tax Code Section 170 allows for the filing of calamity claim by taxpayers experiencing this kind of damage. Numerous counties have denied this claim and afforded the affected taxpayers the ability to appeal that decision within 6 months of the provided denial notice, in accordance with the intent of Section 170. A few counties have searched for a loophole to circumvent the taxpayers' appeal rights, thus denying the taxpayers the chance to appeal the denial of their calamity claim, and denying them the right to have the County Assessment Appeals Board, AAB, review the assessor's office determination. Effectively, these counties have eliminated any oversight from the AAB of the decisions made by the assessor's office. The assessor has done so by stating their denial notice is not a reassessment, or that the calamity claim is not a proper application, both conditions which the assessor's office asserts are necessary for an appeal to be filed. Without the ability to file an appeal, the opinions of assessor's office outlined in their calamity claim denials can never be reviewed or questioned in front of the county AAB. Shouldn't all taxpayers have the right to appeal the notice of determination issued by the assessor's office, and have the right for the AAB to review the merits of the calamity claim?
I suppose that's a rhetorical question.
I believe so.
Okay, thank you. Let's go to AT&T.
Yes, AT&T moderator, can you let us know if there's anyone on the line who would like to make a public comment regarding this matter at this time?
Thank you. If you wish to make a comment, please press 1, then 0 at this time. We'll go to the line of Barbara Brunasso. Please go ahead.
Talk on a step-by-step process of what documents need to be sent in to apply for the Proposition 19 benefit. And I know that was very clearly listed on the Proposition 58 form as to what documents were needed: a death certificate, trust, will, whatever else it was, I forgot. And I would say it's all probably the same for the Proposition 19. And, you know, I didn't see it as legal advice or that I needed to get legal advice or find out what other, somebody said tax options existed. You know, when somebody's decided to move forward with applying for the Proposition 19, they just need the straightforward list of what the documents are to be sent in. And someone mentioned during the meeting that they are researching it and it's being revised. And I'm thinking this form should be able to, you know, be quickly revised and improved and made available so people can actually start the process. And I'm saying this for the information of anybody listening into the meeting, so they're aware. If they want to start their paperwork, just look at the Proposition 58 application form, because that had a pretty straightforward, easy list of what documents were required, and I'm thinking it's pretty much the same thing as the Proposition 19. So that's just what I wanted to put out there. Thank you.
Thank you. We're at the last item for the day, closing remarks.
Colleagues, any closing remarks? Closing is a little bit of a misnomer because we are going to be back tomorrow.
I have some, but I'll wait till tomorrow.
Okay. All right. Well, ladies and gentlemen, we are in recess. We will reconvene tomorrow morning at 10 o'clock. Thank you.